Do me a favor. So actually look this up on your phone, read through it. We'll make sense of it, but I just don't want to hold everyone up as I slowly go through it the first time. And just as you get through it, raise your hand or something for a moment just so I can kind of judge the room and see how far people got. And then we'll go from there. Starting at the top, U.S. judge rules ICO frauds fall under securities law. Now, let's take it point by point, and let's try to actually make this a discussion, because this is not a lecture. This is more exploring how the law gets applied in real life, because when you see it in motion, things kind of become clear or start to make more sense. So there's a basic idea here, which is, there was an initial question about whether tokens, whether ICOs fall within the scope or jurisdiction of securities law in the first place. Remember, the SEC is a federal independent agency of the US government, right? It is assigned the power, the right, and the obligation to administer the securities laws of the United States, but can only do that. Okay? It can't declare war, can't impose taxes, can't tell you what trees you can cut down. It only can administer securities laws. Okay? So there's a question whenever a new thing comes up about whether or not that thing is a security. If it's not a security, it's out. Someone else regulates it. And by the way, I see this at a lot of conferences. Just because something's not a security, that does not mean that law doesn't apply to it. Okay, for example, Bitcoin might not be a security, but anti-money laundering, know your customer, currency transaction law may apply to Bitcoin. So it's not like we only have securities law on this planet. There's commodities law, there's money law, there's company law, there's all this other kind of law. So people you often hear the complaint, well, wait a second, if we don't regulate tokens, people will get hurt. We need to have law. Well, again, just because something's not a security, that does not mean that law doesn't apply. The question is, does securities law apply? So this is fundamentally about whether this token, which these people were selling, fell underneath the scope of securities law. Okay, if it didn't fall underneath that scope, then the SEC would have nothing to say. Someone else might have something to say, but the SEC would have nothing to say. Now, if you read ahead, and we'll get there, there's two parties in lawsuits in the United States. There's the plaintiff, which is the person initiating the lawsuit, that's making a complaint, and the person who's responding to that is the defendant. Okay, plaintiff, defendant. So if you and I have a contract, and heaven forbid you break it, and I get angry and I sue you. Okay, I'm the plaintiff, and you're the defendant. If you cross-sue, if you complain against me, you're like, well, I didn't pay you because your work sucks. Not true, never happened. And you sue me back, then you're a cross-plaintiff. Okay, plaintiff, defendant. There's two parties. What this case was about, or what this ruling was about, and I'll explain what that means in a second, was the defendants, the people who were being sued or charged with doing something bad, filed what's known as a motion to dismiss. Okay? That is a pre-trial motion. They went to the judge and they said, hey, judge, the SEC sued us for engaging in securities fraud, but what we were selling wasn't a security. It was a cryptocurrency. And the SEC does not have jurisdiction. In other words, it doesn't have legal power to regulate cryptocurrencies or currencies at all. Its power only relates to securities. Right? So they were making what's known as a jurisdictional argument. And they weren't even getting to whether or not they were committing fraud. They were just saying, look, this is outside of the scope of what the SEC is allowed to do. Okay? It can't declare war, and it can't attack us for working in currencies. And what the judge ultimately came back and did was he didn't, by the way, CoinDesk and all these other publications, and I love them, they get a little exaggerated or enthusiastic in their headlines and sort of make these blanket aggressive statements that aren't exactly true, okay, or they're not too specific. Now, again, it's a mass publication. It's not written for lawyers. And if a lawyer wrote a headline, it'd be 20 paragraphs long with all these disclaimers and all these things like, okay, what we're really saying is this. But just be aware, because I see people everywhere, and I see lawyers outside the United States overreacting to headlines without actually looking at what actually happened. Okay? In U.S. court cases, there's the jury and then there's the judge. Okay, the judge decides legal issues. Okay, were the elements of this crime present? Juries decide factual issues. Was this person at this address at a certain time? Okay, what the judge did here was he didn't decide whether or not these were securities. He didn't decide whether or not these were fraud. He just said, we're not sure. We're going to leave it up to the jury. In other words, the defendants filed a motion with the court before trial. They said, hey, judge, these aren't securities. Okay, they're cryptocurrencies. The judge said, well, I'm not sure whether they are or not because we don't have the facts about what happened. So we're going to let the SEC and you come to court, explain what happened, and a jury can decide. The finders of fact can decide whether or not you were offering a security or not. Okay, so the judge did not this isn't actually what happened. Okay, what happened is the judge let the lawsuit proceed so that the jury could hear what happened. Okay, but again, I don't blame mass publications for having to do headlines. Okay, now let's scroll down just a notch here. And we're just going to take it paragraph by paragraph because it's like a gold mine. I was actually really happy that she sent this. Okay, and let me clarify something. When two people sue each other in court because of a commercial dispute, you have plaintiff and you have defendant. Okay, when you have a criminal case, in other words, someone can go to jail. Okay, you have the government agency, whoever it is that's bringing the criminal case, and then you have the defendants. So the name for the party that's under attack is the same in both cases, but it's not like the government is the plaintiff. It's just the bringer of the charges. Okay, so let's look at this. A U.S. federal judge. I mean, that by itself right there tells us something. Okay, remember that in the U.S. there's the state level, 50 states, plus District of Columbia, plus Guam, all this other stuff. And then there's the federal level, the national government. Okay? And as we talked about, way back when, prior to 1911, the federal government did not regulate securities and the states did not regulate securities. Okay? Then in 1911, Kansas, remember where Dorothy lives and the scarecrow and everything else, decided to pass the first law. Okay? And then in 1933, 22 years later, finally, oh my God, finally, the federal government passed the 33 Act, the Securities Act, and then the 34 Act, the Securities Exchange Act, because finally, after the Great Depression and all that drama, the federal government, there was enough political push for the federal government to start regulating securities. Now, what I didn't go into was it's hard if you're trying to raise money in the United States, and we want people to raise money, it's hard to deal with the federal government and 50 states. I mean, what a nightmare. That kind of defeats the point of having one big country and one big government. So raising money in the United States, back when everyone lived in one state and just dealt with people in that state, wasn't that big of a deal. Like if I live in California and I'm just selling securities to people in California, I don't need to worry about Nevada or Florida or New York. But it's the 21st century. If you're selling securities, you're basically selling it to the entire country. And to qualify or to deal with every state's law about securities and federal law would drive people crazy. Okay? So in 1996, quite some time ago now, the Congress, the legislative branch of the U.S. government, passed a law that basically said securities regulation is really a national issue. It's a national matter. The states cannot regulate this area anymore. Okay? They can't require you to register with the with the SEC and also register with California, New York, Montana, and Massachusetts. It's just because it was too much. So that law that passed in 1996 said if you register with the U.S. government, remember Section 5? If you register with the U.S. government, you can notify states about what you're doing, but a state can't stop you from selling your securities. Well, thank God, because I don't want Montana stopping my. If I go to all that trouble and expense of registering under Section 5 and spending all that money doing all that stuff, I don't want Montana to go, well, wait a second. We have a completely different system. You're going to apply by this system. I mean, that's crazy, right? So thank God, in 1996, the U.S. government passed this law, and the term is preemption. Okay, U.S. federal securities law preempts state law. So when you have a conflict between the two, the US federal law wins. Now, this does not apply in cases of fraud, okay? It's one thing to register with the federal government and then not have to register with state governments, but if you commit fraud, and we'll go into what that means, if you commit fraud, then the federal government's after you, the state government's after you, and the people you defrauded, the individuals you committed fraud against, they can go after you, okay? Because the federal government is not saying, hey, everyone, if you commit fraud, you're safe up from the states because fraud's not a valid function. Right? Now, a US federal court ruled. Now, what happened here was the SEC brought a criminal case, not a civil case. Actually, I think it would probably be the Department of Justice, but it would be at the instigation of the SEC. Brought a criminal case against two reportedly fraudulent initial coin offerings and was trying to, and ruled that they fell underneath securities law. So let me clarify something else. Contrary to what people think, and I slightly misstated this, so I want to be careful. Contrary to what people think, the SEC is a civilian agency. It's a civilian agency and it's a civil agency. Okay, now what does that mean? That means that they're in charge of regulating securities, administering the securities law. Okay, the SEC does not have the power to bring criminal charges against everyone. They can sue you for money. They can do what's called a cease and desist order. They can ban you from securities markets. They can do all kinds of things that make you miserable, like sending out subpoenas and doing investigations. But they themselves cannot send you to jail. So when all these lawyers go up there and go, the SEC is going to send you to jail. No, they're not. Okay? They're going to make your life miserable, get you divorced, take all your money, and make you want to leave the country, but they will not send you to jail. Okay? What they do is, if someone makes a mistake, okay, they don't register under Section 5, but they should have, or they innocently misrepresent something, they'll take action, but they generally, 99% of the time, won't do anything that will bring a criminal consequence. When you have fraud, though, that's bad, that's a crime. And so what the SEC does is it goes to the Department of Justice. Notice the word department as opposed to commission or agency. It goes to the Department of Justice and says, look, you see those jerks over there? Not only did they break regular civil law, they broke criminal law. Go bring charges against them for fraud, for theft, for embezzlement, for all this bad stuff. And the Department of Justice goes, cool. Okay? Bernie Madoff, cool. Bernie Madoff, if you guys know that name, he's in jail. He's not poor, he's in jail, or he's dead now. No loss. I think he is. So the SEC works in tandem or in coordination with the departments of the US government that can bring criminal charges. Okay, now where do they bring criminal charges? Okay? When the SEC is coming after you, you don't automatically go to court. Okay? It's a civil action, it's a regulatory action. You may appear in front of what's known as an administrative law judge. Not a full criminal law judge, but an administrative law judge. Or you may have a hearing, meaning that you go stand in front of 5 guys and ladies that work at the SEC and you go, please, I didn't mean to do anything bad. Okay, but you don't have a day in court, at least initially. And if they decide anything, you may, again, have to pay your money or do this and that, but you're not going to end up in jail. Okay? But when your life or liberty is at stake because of a criminal case, the agency that's bringing, or department that's bringing the charges, can't have this little hearing off on the side. They need to bring it in US federal court, or in court, because you are entitled to a judge and a jury jury to decide the facts, and a judge to apply the law and do the sentence. Okay? So, a US federal judge, that tells us that almost certainly there was a federal agency or federal department that brought charges, okay, has ruled that a criminal case against 2 reportedly fraudulent ICOs falls underneath securities law. So they were deciding that what these guys were doing fell within securities law. It's a federal action, it's a criminal action. Okay, district court. There's the district court, which is the lowest federal court layer. If you don't like the result in district court, you can appeal to a court of appeals. And if you don't like that result, you can try to appeal to the US Supreme Court. Okay? Now, the US District Court is where every criminal case is initially heard. Okay, you don't jump straight to the appeals court because there's nothing to appeal, and you can't go to the Supreme Court because you don't want to have the Supreme Court check something that the appellate or appeals court did. Okay, every criminal case is initially done in district court. Then if you don't like the result, you can appeal and you go to the appellate court or the appeals court for your district or your area. If you don't like that result, you can try to appeal to the Supreme Court, but the Supreme Court, unlike the appeals court, does not have to hear every case. Okay, imagine if everyone demanded their time in front of the Supreme Court. I mean, this is 9 people. They don't have that much time. So they have to agree to hear the case, and they only do that if the case is deciding an area of law that's important for the whole country. Okay? It's called granting certiorari. It's a Latin term. You're granting the right to be heard or to be seen. So, we like to think that there's 3 levels of federal court. For most people, there's 2, and then if you're lucky, if you win the lottery and get to waste 20 years of your life, you get to go to the Supreme Court. Okay, so district court, first level. Okay, there's a single judge. Okay, district courts have single judges. Appeals courts have a few judges. Okay, they're a panel. There's more than one. That's why you can have a majority and minority opinion. Okay, if you have one person, unless they're crazy, you don't have a majority and minority opinion. And Supreme Court, of course, has 9 judges. I think there's 3 at the appellate level. So this judge, Raymond Deere, ruled Tuesday. Okay, it was a motion, and this person ruled on the motion that a case against a pair of allegedly, as in we're not sure yet, fraudulent ICOs conducted by Brooklyn resident from Odessa, Maxime, could proceed. Not that they're guilty, but it could proceed. They didn't throw it out. Denying the defendant's motion to dismiss. Okay? He didn't say you're guilty. He didn't say you're bad. He just said, we're going to let this thing go forward. Bloomberg first reported. Okay, now, these guys were accused, not convicted, accused of committing securities fraud for selling tokens which represent shares in a real estate venture and a separate diamond business. Okay, now, forget the tokens. Just focus on the word shares, a venture and a business. What are shares debt or equity? Remember we covered this yesterday, sidebar? Yeah, they're equity. Is equity almost always a security? Yes. Right? It's shares in a company, it's shares in a venture, it's stock. So if you forget the tokens, remember, you look at the underlying thing. Okay, you look at the underlying thing. These are shares. These are equity positions in a venture, i.e. enterprise or business. Shares are securities. Do you get to magically make something not a security because you call it by a different name? Did that chair, if I have a security and I call that security a chair, is it suddenly not a security? That doesn't work, right? So just by itself, just on its face, these are securities. You don't have to do any kind of complex analysis. Okay? If you're selling a security and you tokenize that security, it's still a security. It's not like you magically can make it not a security. What this is not about, and I can see this headline really messing people up. Okay? What they should have had a big asterisk here, which is these guys were pretending to sell securities anyway, so this doesn't actually mean anything. Okay? Suppose they were selling tokens that weren't representing securities. Suppose they were selling utility tokens, or tokens that represented commodities. Commodities aren't securities. Or suppose they were selling tokens that represented the US dollar, say call it Tether. Okay? That's not a security. Okay, because the underlying, in the case of Tether, the underlying thing, the dollar, is not a security, it's a currency. And when you have a utility token, you're not selling shares in a company or a business, you're selling what basically is a software license. It's like a ticket to go use a platform, right? So, this genius decided, and I'm using genius, this is like the stupidest guy in Odessa. I can understand why he left, because Odessa is filled with smart people, okay? Sharp individuals. Okay, he left, and he was basically selling tokens. By the way, I don't think this is completely accurate. He was basically selling tokens that represented economic interest, business interest, investment interest in real estate and diamonds. As in you'll make money because they'll go up in value. You'll go bankrupt if they don't. Sounds like enterprise risk to me. Okay. So he said, now accused of committing securities fraud. Now here's another point. Remember that the SEC can enforce the securities laws of the U.S. And you had to be selling or buying a security for it to apply. If I, okay, let me just find something. This is not a security, okay? But remember, if I sell this like it's a security, if I market it like it's a security, does it fall underneath the securities law? Yes, right? Remember the line. If you market your non-security as a security, the SEC will believe you. Okay? These jokers, our buddy, Maxime, apparently, and we'll get to this, didn't have any diamonds and didn't have any real estate. Never issued tokens, apparently. So you could argue that he wasn't selling securities because the securities didn't exist, the ventures didn't exist, and the business didn't exist. Can you imagine going in front of court and saying, Your Honor, when I tried to cheat all those people, the thing I was selling them didn't exist, and the laws that apply to that thing don't apply because I was selling nothing. Does that work? I don't think so. Not even in Odessa. Okay, so the idea is that if you're fraudulently selling securities, and underneath it all, there's not really a security, underneath it all, there's not really business, you don't get to use that to stop the law applying. Okay? The court is going to treat it as if you're selling a security and you're committing fraud when you're doing that. Okay. Isn't this cute? However, prosecutors claim, okay, we don't know this for a fact, though I think it's probably true, that neither of these ventures actually bought assets customers were investing in. So this guy's, what's that expression? When moon, when Lambo? Mr. Odessa here was probably buying a Lamborghini, but he certainly didn't buy any real estate and he didn't buy any diamonds. Okay? You can't turn around and go, Your Honor, all the money that these people gave me to invest in diamonds or real estate, I didn't do it. I don't really have a security. They couldn't have gotten money anyways. Wrong. Okay? So he didn't invest in them. Okay, that's the fraud part. Right? Now, and let me tease that out a little bit. Suppose I want to come up with a new cancer-curing drug, and I really, really want to do it. Okay, and I'm serious, and I'm not lying. And I have a company, I say, we're going to cure cancer. Okay, I got these plans, I'm going to do this, I'm going to do that. I sell stock in that company, and I raise $1 billion. So now I got a company, and now I got $1 billion. And I changed my mind. You go, I like Lamborghinis more than I like curing cancer. Okay? But at the time I was selling the stock, I meant to cure cancer. I just, $1 billion, kids have to go to private school, things are expensive. If I changed my mind, was I committing fraud when I first sold the stock? No, that's right. Because at the time it's true. Okay? Now, am I doing all other kinds of bad things that can get me in trouble? Yes, but there wasn't fraud at that moment. Now, can you imagine going in front of a court and going, Your Honor, I really meant to cure cancer when I took the money, but 2 seconds later, well, I changed my mind. Please don't believe I was meant to commit fraud. And the response to that is, ha ha, right? Because in real life, no one's going to believe you if you say that. Okay? If you collect all this money and then you use it inappropriately, right away or right near the time, they're going to believe that you had the mental state, you had what's called the mens rea, okay, planning to commit fraud all along. And good luck convincing them that you just changed your mind when you saw all that money. They're going to be like, nice, right? So if you collect all this money, now let's think about some token projects. Let's think about some blockchain projects. All these projects that issued ICOs and that got money so that you can build their platform. Are they building their platform? Some of them are, some of them aren't. Some of them are trying to build their platform in Ibiza between getting drunk and doing drugs, 10 seconds a day. Well, we thought about it, Your Honor. Okay. Did they ever plan to build their platforms? I don't know. Can you imagine them in court trying to explain how they plan to build their platforms, but they were in Ibiza doing drugs and drinking all day? Well, Your Honor, at the time we meant to do it, we just got kind of busy. No. All right. So right now we're at a very interesting point in time where all these ICOs raise money. Okay. Part of the reason Ether's through the floor is people are kind of taking a pause and investing because they want to see whether these platforms produce any actual results. Well, will they? I don't know. A lot of the people who raise this money don't know what the hell they're doing, right? Now, $1 billion can make up for a lot of with $1 billion, you can hire people who know what they're doing if you actually go ahead and hire them, right? But there's an article that came out today that most of them have invested their money in treasuries, in U.S. bonds. Okay, now, the ICO money in U.S. bonds. Now.
Another war coming up.
Say again?
Another war coming
Yeah, well, here we go. Now, if I take in $1 billion, you can't efficiently spend $1 billion quickly. I've had some girlfriends who could, but in general, you can't spend $1 billion quickly. Okay, it takes some time. Okay, let's say, she's not that good at spending money. She's only spending $100 million a year. Well, that leaves another $900 million, right? It's smart to invest that somewhere so it stays safe and produce maybe some interest. Okay, so it's not inherently bad that they're investing some of the money they raised. It's a good use of funds. You don't want to leave it on the street. Okay, you need to manage it. But when you're investing all the money you raised and you're not really trying to develop the platform, that begins to look like you never had a plan in the first place for doing what you said you were going to do. You just decided, well, I'm going to issue ICOs while the market is hot. Got the money, and you're like, what do I do now? I don't know, I'm going to do some cocaine. So right now it's going to be interesting to see, there's the wave of lawsuits that happened because people were obviously committing fraud. They never meant to invest anything. They were obviously lying. Then there's kind of a wave of cases that I think are going to happen when people got the money. They maybe meant to do it, but they had no real plan for doing it. And they're going to have a very hard time arguing that there wasn't some fraudulent element in there by some of them. Okay, so let's keep going here. Is this good, by the way? Yes, no? Anyone hating this? Okay, whew. This is the hell raising your arms thing. Okay, now, in the motion, this one cracks me up. I can't pronounce it, Vaslovsky's. Okay, Vaslovsky? Zaslav. Okay, good, you're hired to teach me Russian later. Zaslavsky. His lawyers argue that securities laws are unconstitutionally vague as applied. Okay, that's like an argument from 1933. That's not an argument you can make in 2018, okay? Because when the law first came out, maybe it was unconstitutionally vague. It's not vague, okay? We have the Howey test. Okay, and we don't even have to do the Howey test because if these things really represented shares, one of the first items under definition, remember section 2A1 is the definition of securities? It's blah, 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 investment contracts, blah, 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 blah. Well, one of the first three blahs is stock or shares. Okay, you don't even have to get to Howey. Okay, if the thing is shares, they're shares. It's a security. You don't have to go, is it with an expectation of profit through a common, forget all that. They were selling shares. Okay, that is a listed type of security, right? So securities laws are unconstitutionally vague as applied. Well, if the law was like, hey, don't be a bad person except on a day that ends with the word day. Actually, that's a bad example because every day does. If the law was don't be a bad person, okay, that would be unconstitutionally vague because you don't really know what to do in the face of that law, and it's not fair to be thrown in jail for being a bad person according to the Department of Justice. I mean, who the hell are these people to tell you something? Okay, but the securities law of the United States may be complex. They may take some while to learn, but they are not vague. Okay, you know what you're supposed to do. The default rule under Section 5 is if you're selling securities, you need to register them with the U.S., with the SEC, get the registration statement approved. You need to file your prospectus, get that approved, take the money, and not commit fraud. That's the default rule. Okay, everyone knows it. We're all looking for these exceptions, which we're going to cover today, but that's the default rule. If you're selling shares in a company, that's a frickin' security. Okay, it's not like you're doing this complex Howey analysis about oranges and groves. It's a security. Okay, it's not, this guy's a moron. This is basically, I don't know what else to say, so I'm going to say this. His lawyer's like, oh, man, you're screwed. Well, can we argue that? Sure, how much money you got? Okay, and let's go to the next paragraph here. However, the judge wrote, Congress's purpose in enacting the security laws was to regulate investments in whatever form they are made and by whatever name they are called, citing a previous ruling. Well, that's a ruling in that case, but this is like basic law. Okay, the securities law was to regulate investments, not all investments, by the way, but investments that are securities. Okay, I can invest in a house, I can invest in commodities, I can invest in comic books, and without adding more facts, they're not securities. But so he actually should have said something a little bit different. Congress's purpose in enacting the securities laws was to regulate investments, which are securities, in whatever form they are made. Okay, so the fact that you take a share and you call it's a token, it's a voucher, it's a blah, 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 doesn't really matter. Okay, it doesn't matter what the form of them are. It doesn't matter what you call them. Remember, there's the substance over form doctrine. Sometimes put the other way, form over substance. What is this thing really? Forget the names. Forget the pretty dress you put on it. What is this thing? Is it a security? Is it one of the listed types, or is it an investment contract? Okay. So what he's getting at is that we're not going to be restricted by the narrow language of the Securities Act, which was written in 1933. We're going to look at what this thing actually is, and you can be as creative as you want, but if it is a security underneath one of the definitions, then it's going to be regulated like a security. So nice try, buddy. Come, learn securities law. Okay. Okay, so I like, yeah, sure.
I remember this. What is security, blah, 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 investment contract. Yeah, I remember this.
Mm-hmm.
So now we had this comic book, right?
Now we had this what?
You had the example of the comic
book, right.
Yeah? So if I'm coming and saying this comic book will change in price and value over the next 10 years, it's still a comic book, right?
The underlying thing is a comic book, but you're beginning to kind of sort of market it like a security. But that by itself won't be sufficient. It's in real life, people can sell things all day long. You know, I can sell, because you can sell gasoline that may go up in value, and that's not a security. But you're kind of describing it like an investment, right? Now the next question is there a common enterprise? Not really. You're just buying a thing. Right? You'd have to say, we'll manage your comic books. The comic books will pay you dividends, something like that. But you don't have to go there. Here's what I'm trying to say. If you're wondering if it's something as a security, your first job is to go, is it one of these? Let me see if I can flip it back easily.
This blah, 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 blah investment contract.
Yeah, and the blah, 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 blah actually matters. I was being a little casual about it, but give me 1 second here. Let's see if I can do this. Ba, ba, ba. Hey, look at this. See, and they say lawyers don't know tech. So good, so good, so good. Ba, 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 ba. Okay, later. Well, later's now. Okay. See, when all these people try to get clever, you actually look at the real text, and then all their cleverness, they suddenly shut up. Okay? Section 2A is definitions. 2A1, the very first definition is what is a security? Okay? You have all these obvious things. A note, meaning basically a debt. Stock, i.e. a share. Treasury stock, which means stock of a company that the company itself owns. Like it bought it back. You know, security future, the right to receive, well, it's a longer conversation. Swaps, bonds, debentures, blah, 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 blah. Okay, and there's more underneath. This investment contract is basically saying, if you have something that doesn't fit anything else, but has those elements of enterprise risk, of investment, of return, then we're going to apply the Howey test and see whether or not we're going to treat it like a security, even though it's not one of these other things. But you do not need to get here. You don't have to do that Howey analysis. You don't need to do everything else if you're selling stock, because I don't care whether it's, forget that. It's stock. Done. Okay? The only question is, well, if someone's selling this thing called a chair or a token or something that's not on this list, in the real substance of that thing, is it a security? Despite how they named it. That's what they're getting at. Okay? What these guys were doing, Mr. Odessa, 2015, was selling something that the court described, or the article at least described as shares in a company, which is the same as stock, and saying, oh no, the securities laws don't apply. You don't forget all this stuff. If it's really stock, it's stock. Done. Story over. Okay? If there's something about it that makes it not stock, where we're really not sure, the next question is, well, is it an investment contract? And then you do the Howey analysis, which we'll kind of come back to a little bit. Okay? All right. So, flip back here. Okay, so he said, stripped of the 21st century jargon. You can feel that this guy's old. Including defendant's own characterization of the investment opportunity, i.e. they marketed it, or they sold it, or they led to the expectation, including defendant's own characterization of the offered investment opportunities. The challenged indictment, in other words, the case brought against the person, the charges a straightforward scam, i.e. fraud, replete, meaning filled with, the common characteristics of many financial frauds. So what this person is saying is, it's nice that you call this thing a a fuzzy bunny or a token or a chair. I'm selling, Your Honor, I'm selling a fuzzy bunny. I'm not selling stock. Okay, nice try. Okay, because you yourself, when selling it, characterized it as an investment opportunity. Okay, if you market your non-security as a security, the SEC will believe you. Okay, as such, securities laws as they pertain to the indictment and charges were not vague. Of course, they're not vague. It's obvious. Okay, the 33 Act is written so as to include new words. All right. Now, here's what CoinDesk and every other person who's going to post on Facebook that doesn't actually read anything is going to focus on. Or they're not going to get this part, and we can dive in. Notably, the judge did not say whether ICOs are specifically securities. Right? He's not saying these are securities. He's saying, this case can go forward to decide if they are. Instead saying that this can only fairly be a question of proof at trial, i.e. a fact issue, a jury issue, based on all the evidence presented to a jury. He said, I don't know whether it's a security or not. I don't know how you market it or not, but you know what? There's enough information here that this can move forward. Okay? He's not saying that all ICO tokens are securities. In other words, he didn't even have to apply Howey. Okay? It's basically like a stock. You characterize this thing as stock. You used a new name for it, but I don't honestly care. Let's find out what the truth is. He added that the defendant's primary contention that the investment scheme at issue did not constitute a security, as that term is defined under Howey, is undoubtedly a factual one. Okay, now, I bet if we actually read the ruling, it's a little bit different. But the point he's making here is that test, that four-pronged test underneath Howey, that's a question of fact. Okay, it's not a question of law, it's a question of fact. Was there an expectation? Were they led to that expectation? I don't know. Let's listen to witnesses. Let's listen to him. We don't know. It's not like, oh, wait, let me just apply the law. We don't have the facts yet. All right? So that four-pronged test under Howey, which I think we'll go back over, is a factual question. All right, now, go ahead here. Okay, the judge provided more detail on how the Howey test, the U.S. standard for determining whether something is a security, might apply. This is the judge's version of the Howey test. The question is whether the elements of a profit-seeking business venture are sufficiently alleged in the indictment. In other words, did the Department of Justice spell out in enough detail in the indictment how this could possibly fall underneath Howey? Or did they just say it falls underneath Howey? When I bring a criminal charge, if I'm the government and I'm bringing a criminal charge against you, it's not fair for me to just say, you committed robbery, now defend yourself. Go ahead, defend yourself. Because you're like, what robbery? I may have committed 2, or I may have committed 1 or 3 in your case, right? Right? Which robbery, Your Honor? Come on, the one in Odessa, or the government when they bring charges, when they bring criminal charges, they need to be somewhat specific in their pleading, in their indictment. They need to say, you committed Howey because these things happened, A through Z. And we say that when you apply the Howey test to A through Z, this is a security, you sold it fraudulently, we're going to bring charges. If you just say, oh, you committed securities fraud, and you're sitting there like this poor guy going, huh, what? That's not fair. Okay, so the question is whether the elements, in other words, each little part of the Howey test, of a profit-seeking business venture are sufficiently alleged in the indictment, such that if proven at trial, in other words, a jury says, yes, these things that the government said are true, a reasonable jury could conclude that investors provided the capital and shared in their earnings and profit, and that the promoters, like the defendant, managed, controlled, and operated the enterprise. Okay, now hidden in here is the Howey test, right? Remember, there's an investment of capital or other thing of value. Okay, so the investors provide the capital. That's number 1. Shared in the earnings and profits, i.e. had an expectation of profits. Okay, you kind of put them in weird order, but the promoters managed and controlled and operated. In other words, the investors were passive, remember? Primarily through the efforts of others. That last one, that's what he's getting at. And operated the enterprise. In other words, it's not a comic book, it's a business, it's a platform. Okay, there's something going on that has actual operations, and these guys were investing it. Okay, for the present purpose, we conclude that they are, right? Because it's pretty clear that those elements are at least being properly alleged. Where am I? That being said, an independent analysis of how test, as it may apply, will be required for a final determination at trial. So they're going to actually go to, unless something happens, they're going to go to trial, and the jury's going to hear all the facts and decide whether or not Howey applies. The judge echoed a previous decision he'd made in the case when he first ruled that a jury would decide whether the token sales qualified as securities offerings. This past May, the defendant appeared for a hearing on the merits of the case. Okay. While his attorneys argued that the U.S. SEC cannot regulate token sales as securities, prosecutor said the point was moot as no tokens had ever been developed. Well, who thinks the SEC can't regulate token sales as securities? Okay, glad no one's raising their hand. Of course they can. If you have a stock and you tokenize it, that's obviously a security. Okay. What's more a question is the SAFT situation, whether before you build a platform and you raise money to build a platform, the token may or may not be a security, but eventually, once the platform is built and the tokens are usable for actual things, whether or not they'll stay a security. Okay, but this case wasn't even covering that. I like this. No tokens had ever been developed. Okay, what is he developing? He's investing in real estate and diamonds. Okay, it's not like Telegram or all these other ones where they're taking the money to develop something. That's sort of like a SAFT analysis. Like, I'm taking your money in order to develop something. He could have issued tokens the first second. He could have said, here's your tokens. These are securities. Now, the money you give me for the tokens, I'm going to go buy diamonds and real estate. Well, I mean, what development? It's an ERC20 token that he said is worth something. Right? So they're kind of mixing concepts here a little bit. Right. Does this make sense? Questions?
What if you actually invested in gold and commodities? What would have happened?
Right, so that's a good question. So remember let's go back real quick here. That's a good one. Good question. Here. Oops, sorry guys, I'm having a mouse moving technical issue. Okay, there you go. Okay, so back to our pencils. Let's see if I can do this okay. Sorry guys, 1 second here. Let's just kind of rip through these. Hopefully I can do this okay. Okay, so take your example. Okay, if something is inherently not a security, okay, and you don't market it like a security, it doesn't magically turn into a security just because the government says so. So if you have a pencil, it's not a security. Like if you have gold, let's say this pencil's really gold, right? Gold is not a security. Gold is a commodity, right? Now, what happens when you market this pencil, i.e. this gold, as what it is without adding more information? Okay, that's not a security. You don't magically turn something into a security just by marketing it as what it is. Okay, now here's where we get fun stuff. Pencil marketed as security or gold marketed as security. Okay, when I start saying buy commodities, they'll go up in money, in value. Okay, you're still an investment. I mean, you're allowed to say commodities will go up in value because otherwise, why are you buying commodities? This house will go up in value. You can even say you can buy this house because you can rent it out on Airbnb and make money. Okay, that's maybe an investment, but it's not a security yet. Okay, but when you start lying, this gold will pay dividends. Okay, or here's where it gets more tricky. Suppose you form or you're not buying gold anymore, but you're buying shares in a company that mines gold. Okay, that's a security. What if you invest in a company that trades in gold? Well, even though the subject matter of its business is a commodity, you're buying the enterprise. You're buying an interest in the enterprise. So that's a security. Okay, don't confuse what a company is doing with its business with the investment in the company. They're two separate things. The security relates to your investment in the platform, not what the platform's underlying selling, buying, renting, whatever the heck it's doing. Okay? So, and you get into there's sort of a niche situation here, which is if I sell you gold, and I just sell you gold, I'm not selling you a security. If I say that I am going to actively manage your investment account and you're going to buy and sell commodities under my control, and I'm going to get you a profit because of that, that might be a security. Right? There's something called a managed account. But if I'm simply managing your investments in the sense of handling the paperwork and just keeping your funds safe, but not actively making investment decisions, then the fact that you're working through me does not make it a security. Okay, so if you have all these, there's a lot of ICOs and blockchain startups, I think, that are trying to tokenize diamonds or tokenize gold or tokenize this or tokenize that. That just by itself does not turn those things into from commodities into securities. But suppose that these companies are taking, rather than giving people's rights to individual gold, they're saying we're going to buy a whole bunch of gold. Okay? Your tokens don't give you the right to one particular piece of gold. They're kind of an investment in the overall gold holding business. And by the way, we may sell gold, hold gold, buy gold, try to make a profit that way. Then you're edging up into like securities territory. Make sense? Okay. All right, guys, and this is why I need dialogue and feedback. Was this useful, helpful, not?
But anyway, in this case, it's not a fraud yet.
The gold thing?
Yeah.
No, it's not a, okay, so that's a beautiful point.
It's a security, but it's not a fraud.
Right, keep in mind, go back to the very first, that's a beautiful point. Going back to the very first section, very first page of the Securities Act. Remember, there's two purposes, okay? There's full and fair disclosure of the characteristics of the securities being sold in interstate and foreign commerce. Like, it's scary, that's memorized, okay? And then there's the prevention of fraud in the sale or offer of sale thereof. Two purposes, okay? Full disclosure of information, and then the prevention of fraud, okay? The full disclosure of information part is handled by registering your security under Section 5 with the SEC, because the SEC makes sure, according to its standards, that you provide enough information for people to make a good evaluation about whether a security is what they want to invest in. Remember, the SEC is not saying, we think you should invest in this. This is great. They're not making what's called a merit determination. They're just enforcing the disclosure obligation. Okay? There's Section 5, and we're going to talk about how to get away from Section 5. Okay? But completely separate from whether you need to register your security or you're offering your securities under Section 5, completely separate from that, they also say, no matter what, whether you're registered under Section 5 or not, you may not commit fraud. You can't commit fraud within a single state. Okay? You're not allowed to commit fraud with imaginary securities. You're just not allowed to commit fraud. Period. Done. End of story. Okay, so to take the gold example. Okay, suppose they're legitimate about doing this. Okay? And they're not taking the money and going to beats and getting high and all that stuff. Right? They raise $1 billion. They buy gold, they manage it in such a way as to make the tokens securities and not something else, and not commodities. Suppose that's the case. They may be found to have violated Section 5 and deal with those civil penalties, but based on what I just said, they will not have committed any crime. They won't be treated like they committed a crime, and the Department of Justice won't be able to go after them. So they're going to have the joy dealing with SEC and all that other fun stuff. They'll all get divorced, okay? But they're not going to end up in jail. Only when they start doing securities laws violations, the criminal violations, which is mostly fraud, but can be maybe market manipulation and some other things, do they head over the line into not only did you issue these without doing a Section 5 registration, you also committed fraud, and now the FBI or Department of Treasury is coming after you also, which is really fun, because when you go in front of the SEC, there's that right under the U.S. Constitution that you can't testify, or you have the right, it's the Fifth Amendment. If whatever you say can be used to incriminate you, okay, you're allowed not to answer the question. Well, what happens if you're in front of the SEC? Can they incriminate you? No, they're a civilian agency. Oops. So maybe you do have to answer the questions, because they're not going to bring criminal charges against you. They're just here to make sure you didn't, you comply with Section 5. You get in a really bad situation when the SEC is answering you questions that you have to answer, and then later on, when the FBI brings its case, you're like, you can't be like, I didn't sell those securities. You're like, well, you told the SEC you did as part of your plea agreement. Oops, problem. All right, now, keep in mind there's also a situation, suppose you register underneath Section 5. Okay, you follow the law, or you find a valid exemption. Right? You find a valid exemption, Regulation D, which we're going to cover. That's how you raise unlimited money from unlimited people. I know you're all dying for that one. Right? You follow a proper Reg D exemption, but then you commit fraud. Well, congratulations. The SEC won't come after you for Section 5, but the FBI and the SEC will come after you for fraud. right? So Section 5, registration requirement or its exceptions, fraud. Don't commit fraud, register, or find a good exemption. Okay, so there's Section 5, the registration requirement. Don't do that. Okay. How do you get out from that? How do you get out from underneath that and raise money? Okay, so this is all about Reg D. Okay, I am going to do something that's like from New Wave movies or French movies. I'm going to give you how the movie ends before it even begins. Right? This will make some sense now. It will make a ton of sense later, but here's where we're going. You can raise use Reg D, Rule 506C, to conduct a private placement of securities and raise unlimited capital, billions and billions of dollars, from an unlimited number of accredited investors. Okay, there's Reg D, Rule 506C. You can raise as much money as you want from as many people as you want when these people are accredited investors. You do need to verify, we'll explain what that means, verify that these investors are actually accredited. Do not take their word for it. In other words, they may not self-certify. You have to verify that they're accredited. Do not mess around with unaccredited investors. They have no money anyways. Don't bother them. Ugh. Okay, do not mess around with unaccredited investors. Do not mess around with bad actors. Okay, and I don't mean Arnold Schwarzenegger. Just do not, that's a defined term. Actually, it's not that bad. Do not make any misrepresentation of material facts or omit such facts when offering or selling securities. The last one relates to fraud. Fraud kicks in when you make a misrepresentation of a material fact or omit a material fact when offering or selling securities. Okay, this is the headline, or the headlines. In broad strokes, if you do this, you can raise all this kind of money. You don't have to comply with Section 5. Thank God. Okay, now, what are your core methods for avoiding the need to register your security and get approval from the SEC for your registration statement and your prospectus? How do you avoid that? And just as a reminder, if you have to register under the Securities Act of 1933, you automatically then need to comply with the Securities Exchange Act of 1934. You don't want to do that either. Okay, it's really important to avoid registering under the 33 Act if you can avoid it. All right, so how do you do that? Well, the first thing that we just beat to death is don't sell or offer to sell a security that falls underneath 2A1. Okay, if it's not on that list and it's not an investment contract and how it doesn't apply, for example, it's commodity or it's a currency or it's a bunch of shoes, this completely avoids SEC subject matter jurisdiction. The SEC has nothing to say about it. Right? So by the way, when all these people say, we don't think our token is a security, but we're going to register it with the SEC to be safe, okay, that doesn't fly. Okay, you can't, just like you can't pretend something's not a security by calling it something different, you can't pretend something is a security by registering with the SEC. It does not make you safe. Okay, and what the SEC should do when they get that is bounce it and reject it. Like, why are you registering your commodity with us? It's not a security. Okay, now they're being a little bit aggressive and silly, but just keep in mind, if it's not a security, if it doesn't fall underneath 2A1, either because it's not one of those things or because you don't market it inappropriately, you don't need to register under Section 5. So don't get carried away with Section 5. Okay. There's Section 28, which gives the SEC what's known as general exemptive authority. I'll talk about that when we get to the slide. But general exemptive authority says that the SEC can decide that certain transactions, because of their nature, because they're small, or because of the people being sold to, or because of this, that, and the other, don't need to be registered under Section 5. If it's 500,000 people to your best, $500,000 to your best friends, and you're a well-known business, and it's happening in Guam, I don't know. They can come up with these rules about, they're allowed to come up with rules or regulations that say, look, even though Section 5 would normally apply, we're going to say in this kind of situation, it doesn't apply. Right? Now, here's, the last one's a real punchline, but I'll go to number 3 next. You can avoid registering under Section 5 if you sell or offer for sale an exempted security as defined in Section 3. And we'll talk about all these. Section 3 lists a bunch of things that qualify as a security under Section 2 or under the investment contract definition, but nonetheless do not need to be registered under Section 5. In other words, they are securities. They meet the definition of security, but because of their nature, they're exempted, or an exception is made from the registration requirement, or actually from the entire act. And the fourth one, which is the big one, is you can avoid Section 5 by engaging in an exempted transaction. You're not selling an exempted security that it doesn't get covered by the act at all, but you can avoid Section 5 by engaging in an exempted transaction. Again, we'll explore what that means. All right? So note that exemptions are either directly described in the Securities Act or may indirectly exist pursuant to an SEC rule or regulation created under the authority of the Securities Act. So the Securities Act is neat. It says, okay, these things shall happen. The SEC shall create these exemptions. These securities shall be exempted from registration. The Act also says the SEC may make rules. Remember, shall, may. The SEC may make rules, for example, underneath Section 28, where it can decide that you don't need to register under Section 5. And again, recall, the SEC has delegated authority from the US Congress, delegated. So they are allowed to make these exceptions, and those exceptions have the force of law, and we're allowed to rely on them. Okay, I'm gonna flip ahead to Section 28. I'm gonna do this out of order because this is, in some ways, the most minor one, but it's kind of interesting. This is the general exemptive authority. The commission, by rule or regulation, may conditionally or unconditionally exempt any person, security, transaction, blah, 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 from any provision or provisions of this title or any rule to the extent that such exemption is necessary or appropriate in the public interest and is consistent with the protection of investors. Okay, in plain English, or plainer English, that means that the SEC can make rules or regulations saying that we're not gonna apply the rules to this person, we're not gonna apply the rules to this security, or to this transaction, or to this kind of person, security, or transaction, because we think that it won't hurt the investing public if we make that rule, and we think it's important for the functioning of the securities market. Now, here's one little tidbit. There's several places that are the sources for US securities law. There's all the laws I put up on the screen, the 33 Act, the 34 Act, Trust Indenture, blah, blah, blah. What the SEC, but that's not the end of it. There's regulations also. Every government agency in the US, and I think everywhere else probably, comes up with regulations. Regulations are things that the agency, rules that the agency comes up with because it's been given authority over a certain area, and it's not the Congress that's coming up with all these regulations. Congress just passes law, and then goes to SEC or something else and go, okay, now, we don't even know what we meant. So go write some regulations that make sense, that are consistent with these laws, right? So you have the US Code, which is all the law. Then you have the US Code of Federal Regulations, CFR, which is all the regulations. So the SEC comes up with all these regulations. There's Regulation D, there's Regulation A. Regulations are basically groupings of rules. Okay, so you have the law. Law lets the SEC and others make regulations, and within those regulations, there's rules. Notice here it says the commission by rule or regulation, meaning the commission can make one of those regulations and a rule within it to exempt a person, a security, or transaction. Now, here's where things get a little tricky. The SEC is actually kind of friendly, which is shocking. You can ask the SEC for something called a no-action letter. You can write them a letter and make an application saying, look, we're considering doing the following. I'm considering having a business that invests in diamonds and real estate. I'm going to issue shares in those companies. I'm really going to do what I said I'm going to do. Can you agree, SEC, that these are not securities, I don't need to register them? Okay, so rather than doing what Mr. Odessa did, you can actually go to the SEC and you can say, hey, what is this thing? Help me. I want to comply with the law, but I don't know what to do. Or you can take another case. You know, I'm selling tokenized gold. Dear SEC, I'm not going to market it like a security. I'm just going to tokenize gold. Can you agree that I don't need to register under Section 5? That's probably a more realistic scenario. And what the SEC will do on a per-party basis in response to that is issue what's called a no-action letter. Okay, it's to you personally. So if you go to SEC and go, hey, SEC, I want to have this business where I tokenize diamonds or tokenize gold. Do we agree? And I'm not going to market it incorrectly. Can we agree that you won't bring an enforcement action against me? And they'll do their research. And they go, you know, as long as you do X, Y, Z and you comply with the law, the technical term is that staff will recommend no action. In other words, they're not saying we won't do it, but it says the staff will recommend no action if you proceed as you described. Okay, that's a huge relief because it's almost unheard of for the staff or the SEC to change its mind after it issues that letter. Okay, so if you are doing a $100 million transaction and you're not sure, get a no action letter from the SEC. Okay, that's great. Now, suppose I'm someone else. I'm like, wow, that guy got a no action letter. I'm going to do the exact same thing that this guy did. I'll be safe. Well, the vast majority of the time, you are safe. Okay, those no action letters, if the SEC says this kind of transaction, we're not going to do anything about it, if you yourself later on go read that no action letter and you go, oh, cool, I'm going to do just like that, you're probably safe. But nothing ever happens the same way, twice the same way. There's always differences. There are always little changes. So it's some comfort. It's not perfect comfort. The best thing that the SEC can give you is a rule or regulation saying so long as you meet these requirements, you're safe. That's a much more broad category of thing. But what's left out here is the SEC can't issue a no action letter for a class of actions and has to put in a rule and has to put in a regulation, which is a little bit unfortunate because it's a hard thing to do, to put in a rule or regulation that's going to apply to everyone. So just beware. I'll say, note that this only applies by rule or regulation. No individual exemptions granted by staff opinions, i.e. no action letters, or informally, despite language implying per case exemptions. Okay, because it kind of implies that it can exempt any person. So can I, Gordon, go to the SEC and say, hey, under 28, can I do this? No, because the SEC would have to make a rule or regulation just for me. Okay, by the way, and I've done this, you can actually, even though the SEC comes off as mean and scary, you can call them. You can ask for help. They will answer questions. They will work with you to make a transaction compliant. And especially when you have a registration statement, it's expected that they're going to make comments and you're going to work with them. You can be in the same room with them and they'll help. It's kind of shocking when you see it happen. All right, now, in general, the SEC has been too cautious in using 28. So even though it sounds great that they can completely exempt a person's security or transaction, it doesn't really happen that much. In fact, they've used it for some small exemptions, but those aren't fun. Okay, now here's a broader category. There's exempted securities. Except as, and this is under section 3, except as hereinafter provided, this title shall not apply to any of the following classes of securities. In other words, there's things that are securities. We're agreeing they're securities. Forget the Howey test. These things are securities. But registration under Section 5 and everything else, don't worry about it. Now, you still can't commit fraud, unfortunately. Oh, well. But you don't have to worry about selling these securities in general. So what are the classes? Well, it sounds useful until you get into it. One class is 3A2. Any security issued by the U.S., any territory thereof, or any U.S. state. So U.S. government bonds, when the U.S. Treasury issues U.S. government bonds, it doesn't have to go to the SEC and go, please, can I register the U.S. government bonds under Section 5, dear SEC, little agency, we're big department? No, because it's a U.S. security. Those bonds, under definition of security, you had bonds, okay? But the U.S. government, the U.S. Treasury doesn't go to the SEC and go, can I please do these? Okay, California, when it sells bonds, doesn't have to register with SEC. Cities, when they sell bonds, municipal bonds, don't need to register. Okay? So any agency of government, I think it's also the case that Indian tribes may not need to register. I got to look into that, but you can actually, there's actually a little game you can play there. I have to look into it. Now, here's an interesting one, 3A4. This is worth diving into. Any security issued by a nonprofit where none of the nonprofit's net earnings inure, i.e. go to, the benefit of any private party. Okay, you know how Ethereum has a nonprofit? You know how there's the EOS Foundation? I think Zcash also has a nonprofit. Okay, now suppose when they issue their tokens, those are securities. Suppose. Okay, suppose underneath the investment contract you apply Howey and you're like, yep, security. Okay. Do you automatically need to register those under Section 5? Well, the normal rule is yes, but these are nonprofits. Okay, if the nonprofits issue these tokens, okay, and none of the money is going to the founders or directors of the nonprofit is just using those tokens to build the platform, do you need to register that sale? Okay. What do you guys think? I see a reaction. What do you think? Yeah, it seems like no. It does seem like no. Is this actually being done in the US? I don't know. I looked into it. Everyone's setting up in Zug, I think for tax reasons. But, I mean, that's pretty amazing. Okay, it's not that hard to set up a nonprofit in the US. Okay, it's charity city. And actually, the US is far more friendly to nonprofits than a lot of other countries. Some countries, in the US, if you make a donation to a nonprofit, like a recognized nonprofit, you generally can deduct whatever you donate from your taxes. It's like you never received that money in the first place, and you don't have to pay taxes on it. If I turn around and donate to the Red Cross, I don't pay taxes on that money. Other countries, they're like, well, you can donate if you want, but we're still going to tax you on the fact you have that money. So, you know, now it's an interesting question. If I buy tokens from a nonprofit, am I making a donation? Well, generally I say nice try, okay? Because the law's not saying these aren't securities. Okay, these are securities. They're exempted securities, however. They're just saying that you don't need to register these securities under Section 5, nor should you commit fraud. Yeah.
I was just wondering whether I got it right that Ethereum or EOS, they never kept any tokens for themselves.
Well, see, okay, you're asking a great question. So if Vitalik had sold all that Ethereum for Bitcoin and then took 5% of the Bitcoin for himself, or paid himself some huge salary from the foundation. That's what this is talking about, okay? But suppose the founders are early buyers of the tokens. They give funds to the foundation, and they get tokens back. And then the foundation does great work, and the tokens go up in value. Did they really profit from the sale of securities? Not really. It's more like the securities went up in value later.
Most of the ICOs at the moment have this diagram where it's written how much they sell, how much they keep for later rounds, and how much they keep for themselves.
Right, so
Right,
there's team, there's advisors, there's all this other stuff. The way you should do this, that's a great question. The way you should, right, if there's also what's called the smell test, which if it smells like, you know what, shit, then it is. Okay, we're keeping 90% for the team. Yeah, sure you are. And the team is one guy, and he's in Ibiza, okay, with my $1 billion ex. Now, it's a great question. The way that you should structure these transactions is that the founders, the advisors, everyone else, should, in exchange for their participation, be able to buy the tokens at a very low price in the beginning. It's not that these tokens are reserved for these people. It's that they bought these tokens. Okay? And then what's being reserved is to then later on hire new people, developers, whatever the foundation needs in order to make this token and this platform great. Right? That way you're kind of putting a distance between the sale of securities and these founders, these initial advisors, these initial team members getting some kind of unfair result. Okay? So it's a good planning technique. Right? Did everyone get that? You know that pie chart where they go, distribution of proceeds, and we're going to spend this much on the platform and this much for blah, 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 blah. Okay, if you're a nonprofit issuing, it looks funny to be reserving a lot for your founders. You're like, well, wait a second, you're selling nonprofit securities, you're exempted, but these guys are going to make all the money? It looks like you break this. Well, if those people bought it as opposed to just getting it, then you can't really complain. They help fund the business just like everyone else. Okay, so consider setting up a nonprofit foundation in the US, and you will all have an exempted security. Okay, 389. Any security issued by the issuer to existing holders of that issuer's securities where there's no sales commission paid. If I issue tokens that are securities to people, and I convert those tokens into new tokens, or I issue more tokens to those people in proportion to what they have, I don't need to register. Okay, it's like a stock dividend. Okay, I'll say that again, because I see the expression. All right, suppose I've done my ICO, right? And I've come up with version 1 of my token, and I've issued it to all my people, all the buyers of the token. And I go, hey, people, we've upgraded our network. There's now token version 2. Swap your token 1 for version 2. 1 for 1, that's it. We're not paying any commission to any salespeople. We're not bringing in new investors. We're just same relative position, just upgraded token. Okay, you do not need to register that under Section 5, even if it's a security. Okay, suppose you say to someone, hey, for every 5 tokens you have, look, you bought 5 tokens from us in ICO a year ago. Well, or for every 5 you bought from us that you still have, we'll give you 1 new one. So you'll end up with 6. And it applies to everyone. No commissions are being paid, and you're giving it to existing token holders. Okay, that doesn't need to be registered. That's useful. Okay, so Okay.
One moment.
Yeah.
Sales commission is sales commission only a price for the token, or does it also include, for instance, some operation?
So remember the broker-dealer distinction? A broker is someone who connects 2 parties, a seller and a buyer. They sell directly between them, but I get a commission or percentage as a result. That's a broker. Okay, so if I'm issuing tokens to existing holders of the tokens, not selling, if I'm distributing tokens to my existing token holders, if 5% of it goes to Goldman Sachs, something's wrong. Like, why is it going to Goldman Sachs? That's odd. Okay, or if I just go to my existing token, here's another one, good one. If I go to my existing token holders and you say, for you only, existing token holders, those tokens that I sold you for $1, well, each token that I sold you for $1 gives you a right to buy another token for $1, and the current trading, and we think this can go up in value. In other words, you take in more money. As long as you're not paying commission or sales proceeds to someone, like it's all coming from the investor and you're getting 100% of it, you don't need to register. So that's a good one. So you can, suppose you sell 1 round of tokens to people, and you say, oh my gosh, I don't have enough money. I didn't raise enough. I only raised 1 million. I meant to raise 100 million. Okay? Well, you can get that remaining 99 million from your existing investors in proportion to their investment. So long as you don't pay commission, you don't need to register. I mean, that's nice. Oh, sure.
So in the third point, there's the second. There's a private person. Private party. So what does actually mean by private party? Is there any definition?
Right. It's basically, better way to say it would be a person. Remember the definition of a person? So if you have a nonprofit, and the nonprofit, you're selling tokens or you're selling securities, and it's getting money as a result, or Bitcoin or whatever, you can't have the founders of that nonprofit or the directors or the officers or any human get a share of what's being raised, nor any company that's not a nonprofit or any partnership that's not a nonprofit or some trust that's for the benefit of some people. It's a very broad category. It's fundamentally trying to make sure that you don't go to the world and say, hey, I'm selling stuff for a nonprofit, but then some person's basically lying and take the money for themselves. Right? And there are, if you look in the regs, in the rulings, they have more efficient guidance on this. But the basic principle is the money that you're raising by selling these securities from a nonprofit really needs to go to the nonprofit purpose, not to make someone wealthy. All right, so here's a trick that people play. Suppose there's a nonprofit and they sell tokens or they sell securities, okay? And the nonprofit gets 100% of the proceeds from selling those tokens or securities. They sell $1 million worth of securities and they get $1 million back. Then the founder, who's a jerk, says, you know what? I'm gonna have a management services contract or a development services contract with this foundation. I'm going to provide $100,000 worth of development services for $900,000. Right? Now, all the profits from the sale of tokens or securities went to the foundation. That's true. But what's really going on here? What's really going on is me, the jerk founder, entered into agreement with the foundation where it's going to pay me most of that money to me and way overpay for a service I'm providing. So I'm really kind of rerouting that money out. Does that make sense?
That's allowed?
That's not allowed.
Is that a fraud in this case?
It's tricky to say whether or not, I'd say it's it's a fraud. So I'd say it's a material omission. Now, exempted securities, this is tricky language. It says this title, in other words, this act, won't apply to any of the following classes of securities. Now, that could be read to mean that the anti-fraud provisions of the act don't apply. Hey, as long as you commit fraud and it's exempted security, you're fine. Because fraud is here underneath the act, and the act doesn't apply. So, hey, you're safe. It doesn't get applied that way. Basically, you don't need, what it's really saying is you don't need to register, but you still can't commit fraud. Right? You can't commit fraud no matter what. Now, if you have this plan in mind, I said that you're going to sort of use embezzlement or some shady transactions or something so that the nonprofit is not really getting the benefit of the money that it raised, you may not be making a material misrepresentation because you didn't tell anyone your criminal plan. You were very quiet about it, right? But you left out, you omitted a material fact. Okay, you should have told everyone, hey, you know all that money you're donating? Well, you're donating $1 million, and $900,000 of it is going to go to me, and I'm going to give back $100,000 worth of services. Please sign here. Well, you left that out, so you committed fraud. And the real question is, what makes something material? Right? In that case, if I say, the sky is green when really it's blue, it's not material because it's not relevant to the investment decision. What makes something material is whether or not a reasonable investor would take into consideration that fact when deciding to buy or sell that security, whether it would influence their decision. Right? So if the sky is green when it's really blue, that's not going to influence my decision to buy the security. If I know that the founder is going to embezzle money or cheat the foundation, that would certainly affect my decision. Okay? And they don't tell me that. They're omitting a material fact, and they're committing fraud. So it's a great question. I'd argue also that in addition to committing fraud, the truth is they no longer comply with the definition under 3A9. And if they don't, not only did they commit fraud, but they failed to register the transaction under Section 5. And the legal term for that is they're screwed.
So the court has to prove that you have committed a fraud, and then SEC is coming after you. So it's going to be like fraud. You're going to be liable for a fraud, and then you're going to be liable for breaking the.
Yes, you're going to be hit with the criminal first. Well, the fraud thing. There's two levels of fraud. So criminal fraud has to prove a state of mind. Was known as scienter or mens rea, right? If I, by mistake, take money that I shouldn't have taken, and I really, really didn't mean to do it, okay? I may be an idiot. I may have some problems, but I didn't commit fraud, right? That's under criminal, because you don't want to put people in jail for things that they didn't mean to do. If I'm sleepwalking, go into my car and kill someone, and when I was sleepwalking or there is such a thing as sleep driving, right? People go in some altered state, they go in their car and they drive and they kill someone. Okay, that may be criminal manslaughter in the United States if they were awake, but if they're asleep, they didn't have the mental state that was required for criminal manslaughter. Right? That's criminal. Civil is scary because you can be found to have committed securities fraud without the proper mental state. Right? The real question is, did you omit a material fact? Right? Did you misrepresent a fact? If you did, that's fraud. Okay, you're not going to go to jail, but you're going to have problems. All right, so there's two different standards of fraud, and it gets a little bit confusing. But yeah, I mean, suppose you have a nonprofit set up, and you're selling securities, and you try to comply with all the requirements, right? But I said that wrong, actually. You set up your nonprofit, you sell securities, and you had in the back of your mind that you're going to take money that people put in there out for your own personal purpose in excess of what's reasonable. Yes. Then you committed fraud, okay? And also you fall out of this definition because you did, a lot of the proceeds did inure to a private individual or person. And so this definition no longer applies. Well, you're not exempted from Section 5 anymore. You should have registered. It's bad. So, what do you do? Well, what you could do is you could write the SEC and go, I need a no action letter. Okay, I am setting up this foundation. Okay, part of what's going to happen with this foundation is it's going to hire me to do $100,000 worth of consulting services for $100,000. And here's what I'm providing, and here's the contract we're thinking to sign. The SEC might look at that and go, okay, that's reasonable. We recommend no action. Okay, phew. All right. Or you may say, look, I'm going to provide $100,000 worth of consulting services. Here's my third-party appraisal saying it's worth $100,000. I'm going to provide for $50,000 because I really want this thing to work. They'll go, okay, no action. Like you can't do that if you're not sure. Obviously, the safest thing is you don't want the foundation handing out cash to the founders one way or another right after it forms, because that looks like you're not really making it so the profit or benefit doesn't go to a private person. Does that make sense? Yeah, okay. Yes, no?
Could you please be more specific regarding the last one and the single distribution within single years?
You know what? I'm glad you pointed that out because I missed that, actually. Thank you.
Yeah, because, well, if
No, it's great. I'm glad you said something.
If I'm offering securities in California, it's probably enough to raise the all money in the world.
Yes. All right. So thank you. Now, it's a great question, and it helps explore an idea. Again, remember, at the beginning, there was no securities law. And then the first thing that happened was Kansas came up with law, then all these other states, then the federal government. And remember that the federal government is theoretically limited to regulating interstate commerce, commerce between the states, not within a state, between the states, okay? And commerce between the different states and foreign markets. Okay? The idea was that these states in the US are like little independent countries, and unless the federal government has the right to do something under the Constitution, it's not allowed to interfere with how a state operates. Okay, that's the general idea behind the US Constitution. There's the federal layer, the state layer. The federal government has certain powers. If it doesn't have those powers under the Constitution, those powers remain with the states. So when the 33 Act came out, the big question was, what gives the federal government the right to regulate security sales? There's nothing in the US Constitution about, the founders, they're fighting the British, they're like, okay, you must register with, with the SEC. There's nothing like that in the Constitution. What gives the federal government the right to do that? Well, remember, in the very beginning, it's to full and fair disclosure of securities sold to interstate commerce or with foreign governments. Okay, so theoretically, if the seller is in a state and the buyers are in the state, there's no interstate commerce. Now, 2018, everything's freaking interstate commerce. Like, every packet you use on the internet to sell your security, all the money you're using, your bank accounts, it's so messy right now. It's really hard to argue that something is only happening within a state. I mean, if I buy a hot dog, the things that went into that hot dog, I'm scared by, with what went in there, but that came in from outside the state. And I'm going to do a little bit of a tangent here. I think you're all aware that, the U.S. has had an issue with relations between the races, black, white, everyone else. And from the beginning of the U.S. until the Civil War, blacks in the South were slaves. Then after the Civil War, there's something called Reconstruction. They were all freed. But they lived under a situation where they did not have the same rights as the white people in the country. It was sort of like apartheid in South Africa. Right? And then in the 60s, 1960s, like 100 years after the Civil War, I know people who were alive when this happened. The civil rights movement started in the United States. And they said, this is BS. We fought the Civil War back in 1865, ended in 1865. From that time until the 1960s, we had what's called the Jim Crow system, where blacks went to this school, whites went to this school, blacks could not sit at the counters at cafes in the South. Dogs were after them, judges and jury. You had black people accused of rape with all white juries, and then they got hung, and it was a real disaster. So finally, in the 60s, there was enough of a movement in the United States that said we need civil rights for everyone. We need the equal application of law. We need due process for everyone. It shouldn't depend on your race. You're here, you're a citizen, equal. Well, when you hear states in the South talk about states' rights, it's federal government. You don't have the right to tell us how we're going to treat the people within our state, okay? Because you only have the rights in the Constitution, okay? You only have rights that relate to federal law. You can't tell us how to apply state law to your federal government. Okay, because if some black citizens come to a restaurant and are denied service, okay, that's not interstate commerce. That's commerce in this one little Georgia town where no one ever leaves and they all have no teeth. Okay. And so all these laws that the federal government that got passed at a federal level that were giving people civil rights, the states fought them, saying it's not interstate commerce. You don't have the right to do this law. The U.S. Supreme Court, which remember, ultimately decides the balance between the federal government and the state governments, finally, and it was a real fight, came up with some rulings that said, basically, everything that happens in the United States is interstate commerce. Everything. Okay? If you go to some greasy spoon or some 5-seat cafe in the darkest heart of Tennessee, where no one ever leaves their town, and you buy some locally grown chili, well, what you do there affects what happens in another state one way or another. So we decided that federal law about civil rights is going to apply to you, even though you're not, because you're interstate commerce. Does that make sense? Okay. So, and on one hand, that's a great result because all these people have been, still suffering for a full century after the Civil War. Finally, rather than fighting things in state court where everyone hated them, could sue back in federal court where people hated them less. Okay, and finally, you hold these businesses accountable. Okay, so that, on one hand, that's a great result. On the other hand, if you look at the delicate balance that's between the states and the federal government in the United States, since the 1960s, the federal government has been gaining more and more power, so that the states are less like independent countries, and they're more like departments or oblasts. Okay, so now you can argue we have 50 oblasts. Okay, or provinces. If you look at and that's not inherently wrong. If you look at countries like France, Russia, and I think here you have a oblast system, right? Are governors elected or are they appointed? Does someone run for the governor? Appointed. Okay, so that does not make it not a democracy. But what happens is every election is a national election, and you have a parliament, and then they appoint regional administrators. Okay, so you're moving towards a more centralized form of government. If you look at Germany and the United States, it's different. It's a federal system, right? You have two simultaneous levels of government. You elect your national people, and then you also elect your state people, and they have a division of powers between them. Okay, no one appoints the governor of California. Okay, so hey, wow, they're laboratories of democracy. Say again? Well, he appointed himself. Okay, so, now getting to 3A11. All right. Now, what gives the federal government and the SEC and the U.S. Congress the right to require that someone selling in California a security in California to someone else in California, what gives them the right to require that that sale be registered with the SEC? That's not, back at least in 1933, that's not obviously interstate commerce. It could be intra-state commerce within a state, which is supposed to be the dividing line between the two. Well, unlike with civil rights, which was like a critical issue, or else the whole country was going to fall apart, part of the negotiation that made the 33 Act pass was that states added this exception, 3A11. The senators from the different states said, we will vote for the 33 Act if you allow transactions within a single state to be clearly not having to be registered. Like, I don't want some guy raising $100,000 from his cousin to have to register with the SEC or find an exemption. It's just crazy. It's just too hard. All right. So, yes, you can, if you completely, now, if you're outside the United States and you're selling into California, that's foreign state commerce. That's going to be interstate commerce underneath the definition. Suppose you set up a company in California and you're selling just to other California people. This still applies. You just need to be real careful. You can't set up an office with one guy or one person, okay, and have your main operations be in Nevada. Let me say this better. You can't incorporate in California, for example. Incorporation means form your company because they're formed at a state level, not a national level. You can't incorporate in California, so you're a California corporation, but have your entire staff be in Nevada, sell stock from the California corporation to someone else, and say that that's an intra-state transaction. Okay? Because everyone's going to look at that and go, nice try. Okay? It's like everything else. It's not the form of what you did, it's the substance. Are you really a California corporation then? No. You're what's known as a quasi-California corporation. Right?
I mean, now trying to build maybe rubbish.
So let me finish. So what's happened is, I'm not going to dive too much into it. Happily, there's been regulations that have come out saying that so long as you meet these factors, okay, we will agree that you're really a California corporation. Is more than 20% of your business from here? Is your main headquarters here? Is most of your staff here? Fine. Okay. Are the people buying from you, are they residents of the same state? Do their driver's licenses show that they're from the same state? Right? And when you document that, you can completely this is a useful exemption. So to take your example, New York is the West Coast has a lot of economic power, but New York is obviously the financial engine of the US. New York has a ton of money and a ton of funds. Okay? If you're just radiating for New York parties and you're a New York company, you may very well be able to take advantage of 2A11. Okay? And if you're a high-tech company that's based in California, selling to other California, to California venture funds, 2A11 will be okay. And what were you about to say? Did I answer your question okay?
Yeah.
Cool. Whew. Brother. Okay, there you go. Jan, you're going to ask? Okay. All's gut. Все хорошо? Okay. All right. Okay, now we're getting the money. Okay, so the last one was exempted securities. The security itself is exempted. Now we got exempted transactions. In other words, it is a security. The law applies to it, but the provisions of Section 5, the registration provision, shall not apply to, and there's a nice long list, but transactions by an issuer, remember the first sale, not involving any public offering. This is an exempted transaction you can drive a truck through. Okay, let me say this again. Plain English. You know that Section 5 registration requirement? It does not apply if an issuer, in other words, the company issuing its stock, not later on, if the issuer is selling that stock in a way that does not involve a public offering. Wow. Okay, as I like to say, awesome. Awesome. All right. So under 4A2, an issuer only can avoid the entire registration process required by Section 5 by not engaging in a public offering. And here's another key term. In other words, by doing a private placement of the issued securities. If you, for example, sell your tokens on a private basis, you're not selling them to the world. You're selling them privately. Okay, do I know you? Just say yes.
Yes.
Do I know you? Do I know you enough that I can prove it in court if I have to? Okay, so forget you. All right? I don't advertise to the world. I know you. I know you. Okay? Say what? You can buy my tokens. You can buy my stock. Okay? Don't tell anyone else. Sign this confidentiality agreement. Cool. If we do that deal, that does not need to be registered under Section 5. Now, I can't commit fraud. Right? The other provisions apply. But I just completely escaped the requirement of registering under Section 5. If you give me $500 million and you give me $500 million, I just got $1 billion. I didn't have to register with the SEC. Happy, done. And some person was like, I'm afraid of the US because the SEC is going to make me register. Well, they raised $2 from Abakistan. Okay? So 4A2 is a gift from SEC God. Again, people use this all the time. Right? And it makes sense. You know, if you just to think about it, you know, the whole family and friends thing, people go, well, family, you know, people, it's amazing how many attorneys don't know what the hell they're talking about. Whoa, you don't need to register because you're raising from family and friends. There's nothing in the US law that says family and friends. Okay, there are no family and friends. How do you prove a friend? Whoa, we're friends on Facebook, one of my 5,000. What does that mean? Right? There's no family and friends exception. What they're saying if they use their brain would be, I'm not offering to the public, I'm offering to people that I have a pre-established relationship with and only to them. It's a private placement or private offering of securities to that's my cousin, that's my friend for 5 years, best man at my wedding, someone I've done deals with before, that's a vendor who works with my business. In other words, this is an enclosed group of people. If someone calls up and goes, hey, I heard that you were offering securities to Joe Bob, and I think your deal is great. I want to buy some securities. And you don't have an existing relationship with them. 1 may be okay, 2 may be okay. You start getting too loose with that, you're getting kind of more into a public offering and away from a private offering. But if you have pre-existing relationships, or you work through a broker-dealer who has pre-existing relationships, which is a real thing, it's called a placement agent, and it's great, then you don't have to register under 4A2. All right, so who's excited about this part? You should be. You can raise unlimited funds. You're not excited about raising unlimited money? If I jump down, you are super cool.
But that's only possible in the end if I'm working then with a kind of broker, right?
No, not at all. You can, in fact, most of these deals don't happen with a broker. Look, hold on. Do we all know each other? Are we all friends? Is this on video? Just say yes. Okay, good. Thanks for playing along. Okay, do you all want to invest my token? Just some of you say yes. Okay, good. Thanks. Appreciate it. Okay, there's an argument that this would be a private offering or private placement and would not have to register under Section 5, and there's no broker in the room. It's fine. What I'm saying is, however, if you want to keep things private and you don't have the network of investors around you, but someone else, your broker or your placement agent has a very small group of investors that they work with, and they have existing relationships with those people, you can sort of piggyback on that other person's relationship, okay? But you don't have to do that. And in fact, most people starting businesses don't do that.
What about VC firms?
That's going to be under, okay, so that's not a public offering, right? Because you're saying you have to be, you know, meet these criteria, and we're approaching you directly, and this is confidential, right? So that by itself is not a public offering, therefore should escape Section 5. Now I'm going to show you a more secure, certain way to do that that's built on this, but yes, you would not have to register that. So a VC firm invests in your company and you give it stock back, just under the default rules, you escape from Section 5 because of 4A2, and great, right? I mean, that's great. You just raised $25 million, okay? Now,
is there any relevant restriction, I mean, or limitation whether this private placement, I mean, to the number of the people that probably someone can say that, yeah, we are all members of this golf club, all this, like 1,000 people, and I know they quite well because they are my friends on the Facebook, and
right, how do you know? How do you know when you're safe, right? Okay, so this is useful, but hey, you anticipated my thing here, right? So look at the last bullet point. And what does this mean exactly? What is the dividing line between a public offering and a private placement? How do you know? Okay, if you and I, we've been friends for 10 years, and I was best man at your wedding, and I saved your life in Abkhazia when we were both fighting the sea monsters. Do you remember that? You know, we know each other, so that's a private placement. If there's 20 million of you, well, you know, I'm friends with the world. I'm the next Messiah. Well, that doesn't really count. Okay, where's the line? All right. So, under 482, now, this all changed in 1982, but these factors, I shouldn't say these all changed. This got formalized in 1982 with Reg D, but from the creation of the Securities Act until much later, really 50 years later, when you had something that was clearly a private offering, like what I just said, that didn't get litigated, when something was clearly a public offering, like I'm putting an ad in the New York Times, well, that's a public offering. What do you do in the middle cases? Yes?
But I can write about the project without saying that I want to sell my tokens, right?
Yeah, as long as it's not wink, wink. Huh? Yeah, as long as you're truly talking. You can talk about your company all day long. You can talk about your tokens all day long. The moment you start advertising or implying a sale of or conditioning the market is another term, to be receptive to your security sale, that's when you start crossing the line. So there's nothing stopping me from having a private company and then talking about my company to the public. Okay, I should. That's advertising. That's normal. Okay, there's nothing talking about the fact that I'm going to be starting a company and telling the world, I have this great idea for this new company. We're going to do this. Here's our great technology. I'm going to come up with something called an Ethereum virtual machine. It'll be awesome. We're going to have unstoppable contracts unless I would decide that I want to change everything because of the DAO. Okay, that's all fine. All right, but when you start what's called a general solicitation, you take any comer, you advertise to everyone, then it's pretty clear that you're public. Now, we'll get into this. So, how do you figure out the dividing line? Well, there are all these court cases where the SEC said, you did a public offering. You should have registered under Section 5. And the guy goes, no, I didn't. I sold to my buddies. What are you talking about? They fought it out and they went to court, right? And then the court said, they offered some guidance about where the dividing line is. So here's a list of factors. None of these are determinative, meaning none of these decide yes or no, but they're considered. Okay, so most obvious one, is the offer made, let's break it up into two parts. Is the offer for the sale of securities made to a relatively small number of sophisticated investors? That's actually kind of two requirements. If you sell to one person, it's reasonably clear that it's a private offering. If you sell to 1 billion people, it's reasonably clear it's a public offering. Okay? There's a relatively small number. Now, what does that actually mean? Well, it's going to depend on the circumstances, but if you're under 100, you're more safe than if you're over 1,000. Different cases tease that out. What's interesting is, even though it doesn't say it in 4A2, okay, were they sophisticated? Did they have good advisors? Are they people who do investing for a living? Are they a broker? Are they a dealer? Are they people who know your business? Okay, why? Well, the idea is that why do we have full disclosure at all? Why do we care? Why do we have registration? Because we don't want stupid idiots investing in things that they don't understand. Okay, but if people can, you want to make, or you want to at least give them enough information so that when they make a bad decision, it's not because they didn't have enough information, but just because they made a bad decision. All right? So the need to enforce disclosure, which is what Section 5 is all about, just making sure that people have enough information to make a good decision, isn't as relevant when you have sophisticated investors. These people know how to conduct due diligence. They know how to evaluate what you're offering them. They know how to ask the right questions. They know how to do background checks. Right? If you're selling to people who know what the heck they're doing, then you don't need the registration statement and the prospectus as defined under Section 5. Okay? They can ask their own questions. Right? We only care about protecting the ones who are like, balance sheet, what the heck is this? All right? So that's one factor. Is the offer made to a small number of sophisticated investors? The next factor was, is there no general solicitation or general advertising? This is basically inviting everyone to invest of any other offering by the issuer or its agents. In other words, if I communicate privately with people and I contract with them privately and I don't place an ad or do an email blast, all these silly ICOs that are doing email blasts, that's a general solicitation. Okay, if we have private communications between us and it's not known to the general world that I'm doing this sale, in fact, it may not even be known to the SEC that I'm doing this sale, then that's probably a private offering, okay? Now, next one. Is the issuer providing an offering memorandum, or is there sufficient information about the issuer? Now, Section 5, again, is trying to make sure that there's adequate disclosure of the facts, that people can make up their own damn minds and make their own mistakes. Well, suppose you don't do a full registration statement. Suppose you don't do a prospectus, but you do something pretty good. Okay? You give them a document that really does explain the security. It may not meet all the requirements that the SEC would impose, and the SEC is not even looking on it and approving it. But suppose you provide them something that's complete, accurate, no material misstatements, no material omissions. Well, if you do that, then that's a factor the court will be like, okay, look, that's good enough. We're not going to make you do Section 5. Okay, the investors know the issuer or the issuer's business sector. Okay, that's kind of a version of keeping it private. Okay, if you know me, if we've done business, okay, or you know other companies like mine and you're aware of what's going on, you probably don't need to be protected. Here's the interesting one. The investors are given access to management before entering any sale and may ask questions. If I say, hey, we buy this stock, and you go, wait, I have a question, I go, shut up. That's really bad. Okay? If I say, hey, buy my stock, and you go, I have a question. Does your conviction for fraud last year have anything to do with this? Okay? In other words, they should be allowed to ask questions. Okay? If you don't answer questions, it looks funny. If they're allowed to ask questions and you respond, then you're getting closer to providing full disclosure, and then you don't need the SEC to step in. All right, here's a big one. The investors are looking to hold the securities for the long term and do not intend to quickly resell them to other investors. If I'm selling stock or other securities to people and they are buying them because they want to hold on to them because they're going to go up in value over time, then that's much more private. Those things are not going to go far. Right? They're going to probably stay within the initial group for a while. If I'm selling them to you and your intention is to turn around and sell them 10 seconds later, or if you look at these token sales, my 90-day waiting period is over, I can sell them now, right? Then you're not really buying them because you want my platform to perform well. It's not an investment. You're buying them more like a dealer. You're just quickly wanting to flip them over. Well, you get enough people doing that, it goes public fast, right? So they're really making sort of an underwriter distinction here. Because remember, an underwriter is someone who helps you distribute your securities when you yourself can't do it. So Goldman Sachs provides underwriting for companies that look to go public. Okay, am I selling to a small group who are going to hold on to these things? Or am I selling to a small group that's going to immediately turn around and try to sell it to everyone else? Right? So when all these advisors, all these team members, everyone else on these token sales turns around, and the moment, as soon as they can, hey, wow, there's an exchange that listed, great, I'm selling everything. They didn't really buy it for the investment purposes of the token. They didn't buy the token to use the token. They bought the token not to invest but because they quickly wanted to turn around and sell these things. Oops. All right, and the last one, the degree to which the transaction is confidential. Right? When you're relying on 482 and you're sending out information, especially when you're sending out offering documents, I personally number every single one, note which investor is getting which document, have them sign a confidentiality agreement, and limit who they can show these things to. If I have a limited amount of documents and I track each document and I at least have them commit to not distributing them, then it's confidential, and it's hard for anyone to argue that this is a public sale. Right? So these are the factors that the court looked at. Now, this is a lot more safe than, or a lot more certain than this general language, but it's still somewhat subjective. Yes, ma'am.
How long this term should be?
Generally, it used to be 2 years was good. Okay. Then it got kind of crunched down to 1 year. Now there's a clear rule. Oh, no, it used to be 2 years, but it was vague. Now there's a clear rule under something called Rule 144 that tells you exactly what's okay. But you'll note when people sign investment documents, when you're drafting these things, I mean, I think there's a lot of lawyers in the room. When people are drafting, all right, so when you're selling stock to someone, when you're an issuer, okay, the document usually has one of two names. It's either a stock purchase agreement, okay, or it's a subscription agreement. Okay, if you look at the documents, they're usually titled that. And then you have a section of the document that is buyer's representations and warranties. Okay, the seller represents and warrants this, i.e. promises this, or says that these things are true. The buyer promises that these things are true. All right? Underneath the buyer representations and warranties, there's always a representation there that they're buying these securities for their own account, they're buying them with an investment purpose, and they do not have the intention to turn around and resell these things quickly. Okay, sign here. All right? The reason that that's in there is so that underneath this 4A2, when they're not registering the transaction, that the person issuing the securities, the seller, can say, look, I got everyone's commitment. They're buying this for a legitimate investment purpose. Now, the courts are going to look into what actually happened, but that's a fact that helps you. Right? So when you're drafting things always look for that language. To answer your question. Cool. Yep.
The third point makes me confused. The issuer provides either an offering memorandum.
Right, okay, so I didn't cover the second part. So, okay, again, Section 5 is all about making sure that investors have enough information so that they can make an intelligent decision about what they're buying. We're not deciding whether or not this thing's a good investment, right? And Section 5 is the SEC has to receive and approve those documents before you can sell. In other words, before you can do a public offering to everyone in the country. Now, what if you provide enough information so that they can make a good decision, but you're not getting that information approved by the SEC? Well, that doesn't mean the information is bad. The information can actually be really helpful, right? And the closer you get to providing enough information that's like a registration statement or like a prospectus, the safer you are, right? So when you're selling, I do this all the time, even if you're selling privately, even if you're not under 482, you don't need to register with the SEC. I personally say you always give people a written description of what they're buying, the company and the security, that puts in everything material and doesn't leave out anything material, so that it's good business because you're getting so close to the SEC requirement that even if you somehow blow this exemption, you're still mostly okay, or you'll fall more underneath this exemption. Now, suppose I don't do that, okay? But suppose everyone knows everything about me because all that information is public, or most of the material information about me is public. If most of the information about me is public, and everyone knows it, do I really need to provide a separate document saying the same thing again? It's kind of redundant. Okay, that's why you have that separate exception, or there's sufficient public information about the issuer. So, for example, if, take a futuristic example. You have a distributed autonomous corporation. Okay, you have Vitalik's dream comes true. It's 2025, and everything that this company does is not some kind of piece of internal information. It's all there on the public blockchain. It's operations, where the money goes, what it invests in, the voting. Everyone knows everything about it. Now, someone may actually own it, but suppose it's fully publicly available, and you can just audit it to see what's going on. Would that company have to do an offering memorandum? No, you just go look at the record, and you see what's going on. Okay? Okay. 482 is a gift from SEC God. This is like another gift. Regulation D is a way of knowing for a fact that you've complied with 482 and you are safe. Okay, if you comply with Regulation D, you are safe. Forget those factors, forget a judgment call, forget an analysis letter, you're safe. You comply with the Reg D, you're safe. Okay, do Reg D. All right, now, what is Reg D? Remember that there's law which is by the Congress, and And then there's regulations. And then within regulations, there's groupings of rules or clusters of rules. Regulation D is something that was put out by the SEC. It's a cluster of rules, which are now 501 through 508. And they came out in 1982, the first version, and they've been improved over time. And the legal term in the US, it's the safe harbor. Okay? It's the ocean, it's a storm, there's a safe harbor. You go in the safe harbor, and no matter how hard the winds are blowing, and I know I'm outside of the camera, no matter how hard the winds are blowing, your ship is safe, because you're in a safe harbor. Okay? You need to make sure that you're in the safe harbor, and not like at the entrance to the safe harbor, not you're 2 miles away, not the front of your boat's in, but the back's out. No, you need to be inside the safe harbor. You need what's called bright line rules, clear rules. Yes, no, I'm in, I'm out. Okay? And if you're in, you're safe. Okay? The SEC, God bless them, provided that. So, if an issuer complies with Regulation D, the issuer can be sure that the issuance of securities is exempted from registration under Section 5. Okay, now, these Reg D safe harbors are based on 3B, which we didn't cover because they're small, and 4A2, which we did cover. It's basically saying, in the whole world of things that are private offerings, we don't know where the borders are, but if you're within this circle, you're okay. Out here, take your chances. We'll look at those other factors. If you're within here, forget the court, you're safe. If you're out here, lawsuit time. All right? Now, within Reg D, there's several little exemptions. The one that's amazing is what's called Rule 506. There's 504 and 506. Forget 504. Yeah. 506. All right? It relates to private placements under 4A2. So you have 4A2, you have Reg D, you have Rule 506. Then we had something in 2012 called the Jumpstart Our Business Startups Act, which is really a long, stupid name, but they just wanted to be able to say the Jobs Act. We're creating jobs. Okay? So the Congress and the President signed the Jobs Act. Actually, it was Obama. And that resulted in a major revision to Rule 605 that made it beautiful. Okay? And there's two variants of Rule 506, rather. Two variants. There's 506B and 506C. Okay? 506C was put in by the Jobs Act. And then finally, the SEC made that 506C, and now it's live. All right. Now, just in general, these rules apply to any Reg D exemption, including 506, so this matters. Okay. Just be aware, if you're looking at the code, Rule 501 has definitions that apply to all Reg D. Rule 502, actually, I am going, that's all complex, I'll skip that one. Rule 503, and this is key, requires issuers to file a Form D with the SEC when they make an offering under Regulation D. Okay? You have to file a form with the SEC when you use the safe harbor. In other words, if you go in the safe harbor and you comply with all the requirements, but you don't let the harbor master know that you're there by giving them a form, they can be like, well, that's nice, thanks for being in the harbor, but you're not safe. We're going to do the analysis under the other factors under 4A2. Right? So you have to comply with all the rules, and then you, actually before you sell securities, or within 15 days of your first sale of securities, you file a Form D with SEC. Wait a second, and I'll go into this more, but wait, I'm back dealing with SEC? I thought I escaped doing that under Section 5. No, you're not filing a full registration statement, you're not getting approval prospectus, you're just, it's a 4-page form, which is short for the US government. File. Okay, thanks. All right, now, 507 penalizes issuers who do not file a Form D, so it's not optional. All right, and then 508 provides SEC enforcement guidelines related to Reg D. 508 is actually, I think it's under 508. 508 is actually kind of nice because it says that if you make a small mistake that doesn't really hurt anyone, we're not going to kick you out of the harbor. Oh my God, I dotted an I, but not the J. Okay, fine, you're safe. Okay, it basically is telling the SEC to not be jerks. Okay, now, 506, here we get into the meat. All right. What is Rule 506 in general? A and B, this applies to both. Every offering under Reg D, under Rule 506, is a private placement offering under Rule 4A2. Okay, so it's exempted from registration. Every one. This is the beautiful part. There's no limit on the offering size. I can raise $1 billion, €1 billion, I can raise $1 trillion. There's no limit, there's no cap. I can raise unlimited money. Okay? There's no limit on the number of accredited investors. And I'll get into what that means. But recall that the slide before said it's a small group of sophisticated investors. I don't know. Are you sophisticated?
Not yet.
Not yet. Well, you're getting there, right? I don't know who's sophisticated. Are you sophisticated? You look sophisticated. I don't even know what that means, like sophisticated. Well, I read Facebook every day. Okay, no. Okay, accredited investor is a defined term, so you know that this investor is okay. And we'll get into what that means. So no limitation on offering size, no limit on the number of accredited investors, who actually, by the way, are the ones with the money. You have to file Form D with the SEC. You have to watch out for bad actors. We'll get into that. The resulting securities are restricted under rule, and you can get out of that restriction under 144. Okay, now to your point. Remember, if I sell securities to people and then they don't have investment intent, their intention is to quickly turn around and resell them. That's more like a public offering, right? Because these things are going to quickly spread. And the fact I only sold it to a small group in the beginning is kind of a joke. Because if I sell to a small group and they quickly resell, it might as well be a public offering. Well, is it 2 years? Is it 1 year? What do you do? Blah, blah, blah. Well, if you take advantage of the safe harbor, right, the people who buy your stock are generally not allowed to resell that stock unless they register underneath Section 5. Oh my God, that's terrible. You're going to let some poor guy who bought your stock have to register under Section 5 and pay $1 billion to do that? Ugh. Well, yeah, unless an exception applies. And that exception is found in Rule 144. That's a way of keeping the initial purchasing group small, but letting people know, despite that, there are circumstances when they can sell to other people. Okay? So it's keeping that initial purchasing group limited to the initial purchasing group. Okay? And of course, management's available to answer questions. These should look somewhat familiar. These are sort of the bright line versions of the factors that we talked about the court applying before. Okay? Now, there's Rule 506 and Rule 506C. And before we get into the nitty-gritty, I'm going to talk about what these mean, because these apply to both. You cannot escape these, and you want to use these. Okay, what the heck is an accredited investor? How do we know if someone is sophisticated enough that we don't need the SEC to make them receive a full registration statement and prospectus? Well, the SEC in its wisdom said if they have enough money, even if they're stupid, they can hire someone with a brain to help them out, or we'll assume that they're smart. So who's an accredited investor? Remember, with accredited investors, you get an unlimited number of them. Well, if they have annual income of $200,000 or more, or $300,000 with their spouse, for the last 2 years, with the expectation of earning the same or higher income the next year, they're accredited. So all your friends who earned more than $200,000 or more than $300,000 with their spouse for the past 2 years, and they think they're going to earn that the next year, they're accredited. They're assumed to be sophisticated. If they have a net worth exceeding either $1 million, either individually or with their spouse, they're accredited and assumed to be sophisticated. If the investor is suppose they have no money, suppose they have $1 to their name, $1 per person, okay, but they're a general partner, executive officer, or director of the issuer. In other words, I have a company, okay, I'm the president of that company. Or I'll give a better example. I'm the chief technology officer of that company. Okay, I just had a horrible divorce, I had no income, I have no assets, okay, but I am the CTO of that company. Well, I'm on the inside of that company. I have access theoretically to all the knowledge I need. I mean, I am the CTO, right? Then I'm assumed to be accredited. I'm assumed to be sophisticated at least about that company and the securities being offered. Okay, so I'm accredited. Now, certain entities are assumed to be accredited. So, for example, there's something called a private business development company. If they have assets of $5 million or more, I think they can hire someone who can help them out with their investment decisions, even if they don't know what the hell they're doing. Here's one that's interesting. An investor who can demonstrate sufficient professional knowledge of unregistered securities. What kind of test would that be? I don't even know how you would apply that one. I mean, if Warren Buffett came up to me and said, I want to invest, I'd still want him to sign something showing he makes over $200,000 a year. Now, here's something that's interesting. Registered brokers and investment advisors. Registered brokers and investment advisors. In other words, they're registered with the SEC, automatically qualify. So every registered investment advisor in the US and every registered broker is automatically accredited. So all these people can be offered these securities under these rules, and you can do an unlimited number of them. That's freaking great. Okay, here's Form D, or the top of Form D. Okay, you have to file Form D. File a Form D with the SEC. Now, notice the name here. Notice of exempt offering securities. Notice. Notice the notice. Okay, this is the notice of exempt offering of securities. The key word is notice. The SEC is not approving anything. You're just saying, hey, buddy, I'm going to issue some Reg D securities, just so you know. And the SEC goes, thanks, cool. Okay, as long as you're not committing fraud and you fill this out completely, you're good. Okay, it's not begging for approval of securities. It's not please, please, please say my prospectus is okay. It's just, hey, SEC, there you go. And SEC's like, oh, all right, nice, thanks. All right, this is so they know what's going on. Ooh, but this is a little scary. Intentional misstatements or omissions of fact constitute a federal crime. Okay, so when you fill this thing out, okay, make sure you do it correctly. So, hey, here's a little notice. And by the way, I'm committing fraud, and I'm not telling you about it. Okay, well, then you'll get in trouble. All right, so the rule is when you first sell a security, the very first time you do it, you have between then and 15 days to file a Form D. I say that the very first second you know you're offering securities, you file a Form D, just so that there's no question. And you can always amend it later. Okay, now, bad actor exemption. The SEC, are we doing okay? You live? Hello?
Actually, that was a complete form?
No, that was the top of the form. You will never see a US form that is that small. Ever, ever, ever.
I think so.
Ever. There's a form called "This is a Form." No, there isn't. But no, you'll never see it. No, it's like 4 or 5 pages. But it's not bad. It's really not bad. It's just like, here's the issuer. How much? Here's what you're issuing. Here's the exemption you're using. You sign here to certify that everything's kosher. Great. Okay. If you can't fill out this form and you're raising over $1 million, your investor. Okay. This is like the Darwin test. You know Darwin, obviously evolution. If your issuer, with your help, can't figure out this form, they have no business raising $1 million from these poor investors. And then they have to do a Form D. Right, and you want to buy, and you're going to set up like the next Ethereum. Good luck. Okay, no, forget it. Do a Form D. Okay. It's on video. You can watch the replays. Okay. Okay, now there's, like everything else. Wait, this is a great thing. I can do whatever I want. No. Okay, there's part of taking advantage of Reg D, Rule 506, B and C, which is you lose that exemption. Oh, no. You lose that exemption if there's a bad actor involved. What's a bad actor? It's when a covered person has had a disqualifying event. Not the whole population of humanity, but a covered person, which is a certain group, has what's known as a disqualifying event. Okay, so you have an issuer who wants to do a private placement of securities under Rule 501 and then be exempt from having to file the registration statement under Section 5. That's us. Yay, I file my Form D and doing this. Okay. There are many individuals and companies which are considered covered persons under Rule 506D. You need to figure out who those people are, and I'll show you how to do that. So you got this population, you got this group of covered people. Okay, I have my group of covered people here. Now, did any of these covered persons have a disqualifying event that will result in them being found to be a bad actor? You want to issue securities, you have your covered people. Did any of them have a disqualifying event? Yes, they did. Oh my God, look at that unhappy face. Okay? Then you cannot use 506, you cannot use Reg D. You need to file a registration statement with Section 5, under Section 5, or you need to pray and hope that Section 482 applies. Okay, 482 does not have this bad actor thing. Okay, if it's a private offering and you don't do a Reg D, you can hope and pray that Section 482 applies, and you may be right. You may be okay. All right? But if you want to be sure, if you want to do that safe harbor, you need to make sure you have no bad actors there. Okay. If none of them are bad actors, all good. That's a happy face. Your exemption survives. You're exempted from having to file a registration statement and prospectus with the SEC under Section 5. Okay. You got bad actors, you got covered people. Okay. Who the heck is a covered person? How do you know if you're covered? You know, is my mom a covered person? Who knows? Okay, well, it's the issuer, obviously, including predecessors of the issuer. In other words, entities or people that came before it. So if I have a company that gets bought out by another company, that could be a predecessor to that next company, or if I got a company that changes its location of incorporation from Nevada to Montana, that's a predecessor, right? Or affiliated issuers, okay? I own half of that company, I own half of that company, I'm a bad actor, right? Let me use a better example. This company owns half of that company, right? And if they're both issuing stocks, if either one of them is a bad actor, that kind of bad actor thing can poison over because of the affiliation. Okay. Directors, executive officers, or other officers participating in the offering, general partners, managing members, etc., of the issuer. So if the executive layer of the issuer is considered covered persons. If the janitor has committed a disqualifying event, it doesn't matter because that's not a covered person. Okay, the management of the company are considered covered persons. Here's a tricky one. Direct or beneficial owner of 20% more of the outstanding voting equity of the issuer. Suppose you have someone who owns 20% of the company. They're not an officer of the company. They're just sitting back quietly. But they've had a disqualifying event, well then they're a bad actor and you can't use Reg D. So you got to check out who your investors are, or at least your current owners are. Okay, any promoter connected with the issuer at the time of sale. Everyone buy this stock, it's great, it's great. Well, if I've had a disqualifying event, that's a problem. Here's one. Any person or company compensated for soliciting investors. This includes management of such a company. So what's common in the token world is that people pay kickbacks or commissions to people that are facilitating token sales. So when that friend recommends that ICO, come on, buddy, invest $1 million. It will do great. Okay, of course they're getting paid 5% or 10% or 20% by the issuer. Okay, they're getting compensated not only breaking broker-dealer law, they're being compensated for soliciting investors. If they've had a covered disqualifying act and they're being compensated for soliciting investment, they're a bad actor. That make sense so far? Okay, so this is the world. You need to identify your covered persons. Okay, now what actually is a disqualifying event? Are they mean to their mom? Did they not get their girlfriend roses? Did they jaywalk? No. Okay. This is what are disqualifying events. Okay, this will turn a covered person into a bad actor, and if that happens, your Reg D exemption is in danger of being lost, unless you kick them out the door really fast. All right. Has the covered person had a conviction for a felony or misdemeanor or order of injunction relating to the purchase sale of a security or making a false filing with SEC or some other things? In the US, a felony is a crime where you can be put in prison for a year or more. Okay? A misdemeanor is a crime where you can be put in prison or in jail, but for less than a year. Okay, that's the distinction. Okay, in real life here, it doesn't matter because if it's less than a year and more than a year, basically, have they been convicted of a crime? Okay, so has a person been convicted of a crime or order of injunction? That means have they been ordered by the court to stop doing something or to do something? Like they were about to commit fraud and the court said, no, don't. Or they were about to not issue securities and the court said, yes, you must. All right, that's an injunction. Okay, has a covered person been convicted of a felony or order of injunction relating to the purchase or sale of security or making a false filing with SEC? Well, that makes sense. If someone's been convicted for securities fraud, like this joker from Odessa, okay, they're a bad actor. All right? If the court gives an injunction to them saying, stop stealing money when you sell securities, okay, that's an injunction, they're a bad actor.
Is there some period for which to buy, so it's forever?
That's a good question. I think it's 10 years. I should double check. There is a period where it goes away. There's also, these rules came out in 2013. So if they convicted, it's either if they were convicted of a crime before then, or if a filing was started before then, they won't lose the exemption. I can find out. I'll bring that information tomorrow. Good question. Do you know anyone? Mm-hmm. I want a commission on the answer. Okay. Odessa. There you go. All right. Now the SEC does not have the power to regulate everyone. Okay. The only thing the thing that brings you into the SEC is selling a security, so it doesn't regulate everyone. But there are people it does regulate. It regulates financial advisors, brokers, dealers, underwriters, all that other stuff. Those people need to register with SEC. That's a whole separate bunch of law. But if I'm a financial advisor or broker, I need to register with SEC. Okay. Once I register with SEC, I'm subject to regulation by the SEC. And if I do a bad thing, like cheat my clients, okay, I can have an SEC order issued against me. You may not be a broker for a year. You need to keep better records. You need to allow us to audit you, blah, blah, blah. Okay, so look at the last example.
Well, it's not about being a broker, it's about being a broker who got an order from the SEC.
Right.
Okay.
Right. Brokers are fine. You're not disqualified by being a broker. It's the question, has the SEC been a bad broker? Okay, now, here's a tricky little connection, right? Any person or company compensated for soliciting investors. All right, if you hire a broker to sell your tokens, or you hire an underwriter or dealer to sell your tokens, and that broker or dealer or someone has an SEC order in their past, you can lose your exemption. Right? So there's a whole class of people out there who specialize not in the public sale of securities, but in the private sale. They're called placement agents. Right? So your entrepreneurs don't necessarily know how to find investors, but they can find people who have investors. And if these people are licensed brokers, and many of them are, right, then that's great. You pay them a 7% commission. You raise $100 million, give them $7 million. You're like, wow, oh well, I had to give up $7 million, but I got 93. And you're paying these guys a commission. Well, if any of them have a conviction, an order, or they're under discipline by their self-regulatory organization, you can lose your exemption. Okay? So when you're hiring these private placement people, when you're hiring these brokers and everything else, you make them put into the agreement. They represent and warrant that they don't have a conviction, they don't have an order, they're not under discipline, sign here. Okay? And if they fall underneath any of those things during the term of the offering, they have an affirmative obligation to let you know. Okay, so when you're drafting these, I'll say it again, when you're drafting your agreements with your resellers of your tokens, okay, or your stock or whatever, you need language in the agreement, okay, that basically says that they're not a bad boy, and that if they become a bad boy during the part where they're selling the tokens or the shares, they need to let you know. You have written in there, you can end the agreement and not pay them compensation. So you can. You didn't commit fraud. Remember, so here's what happens with Reg D. This is a safe harbor. Okay. I'm gonna just make it real clear. Section 5, register your sale. Okay. Section 4A2, you don't need to register your sale because it's a private offering, not a public sale. I don't know. What does that mean? I don't know. Reg D, specifically Rule 506, but Reg D in general. Okay. Now we know it's a private sale. We don't have to kind of guess right here. We don't have to go to court and figure it out. We know. Okay, if you lose your Reg D because of your bad boy exemption, you didn't commit fraud, but your boat is now in 4A2 land, where you better hope that it's a private offering and not a public sale, and you may have to go to court to fight it. Okay, you didn't commit fraud. You know, if your broker was convicted of a felony last year and doesn't do anything wrong with your sale, how did you commit fraud? Okay, but you're not allowed to use that person and also use Reg D.
Yeah, but that's the point. I mean, it's all a question of information. And if I don't have all the information, if I didn't make my due diligence, or I make good due diligence, but I didn't find anything that he was having a SEC order, or in the paper he signed, no, I'm fine, I haven't done anything.
Right. Okay. So it's a good question. So the brokers, if there's a group called FINRA, or organization called FINRA, that regulates financial advisors and I believe brokers also in the United States. Every broker is given a number. Okay, you can go to the FINRA website and look them up, and I have. You can see what states are registered in, what they can do, what brokers or companies are working under, what tests they passed, and you can see their public record of discipline. All right, so there we have a publicly available resource that you can check. You better frickin' check. Okay, now. Criminal convictions, you know, there's resources available to lawyers and other where you can go look people up and find it out. Right? I've had situations where people have had criminal convictions, but they haven't had a criminal conviction relating to securities. Okay, so if you murdered 20 people and got convicted and spent 10 years in jail and get out, I don't know if I want to have dinner with you, but you're not a bad actor. Okay? Maybe whiskey. All right, so you check as much as you can. Now, you don't automatically, you know, the SEC can waive a violation of this. They say, okay, you did a really good job. You got ambushed. We'll let you off the hook. They can do that. Right? And the question is going to be, did you really do a good job looking into it? And what did you do once you found out? Well, you know, we'll keep that guy on. He brought in $20 million, whatever. Oh, wait, we got busted. Nice try. Oh, wait, this guy committed a crime. We just found out about 10 minutes later. You're fired. Okay? So you can, at the very least, when you document your relationships, you build up ammunition that you can use with SEC and say, please don't kill me. I want Regulation 5 to apply. Sorry, D to apply. Okay? Yes? Okay. All right, so this thing, the covered person is suspended or expelled from membership in a national securities exchange or securities association. Keep in mind, so the SEC can impose discipline on brokers and investment advisors, but every investment advisor is part of FINRA. Okay, and if you're also the New York Stock Exchange is an example of a national securities exchange. People become members of that exchange in exchange for the right to operate on that exchange. The New York Stock Exchange has its own disciplinary system. So if I'm a market maker, for example, on the New York Stock Exchange, and I've been cheating my clients, even if the SEC doesn't do anything, or even if there's not a felony, if the New York Stock Exchange subjected me to discipline, then I'm a bad actor, or that's a disqualifying act, I should say. And there's others. Here's an interesting one. Disqualifying events do not include anything that happens outside the United States. So in Monaco, I'm laundering money, I'm selling invalid securities to tons of people in the EU. I get thrown in jail. The German regulatory body, BND, whatever it is, imposes discipline on me. I have newspapers filled with stories about how I cheated investors, went to jail, were subject to orders, and killed my dog. Okay? None of that matters. Why? I don't know why. Why? Because we don't really know other legal systems, and we're just caring about the U.S. All right? So, someone could do all those. They're not going to be a bad actor. No, that's not a disqualifying event. Now, here's another question. If someone got convicted for securities fraud in France, and they're the treasurer or chief financial officer of your company, okay, that's not a disqualifying event. They're not a bad boy. But is that something you should probably reveal? Is that a material fact? I'd probably want to know that, at least, just me. So you don't get away from having to reveal it, but you don't automatically lose Reg D. You should just probably disclose it, but it depends. Okay, now to your point, this is the next part of Reg D in general. Okay, recall that public offerings of securities must be registered unless there's an exemption. That would generally apply to resales of restricted securities. Everything that comes from a Reg D is a restricted security, or control securities, acquired directly from the issuer. Okay, so when someone takes advantage of Reg D and I distribute securities, people will buy it. Those are restricted securities. You generally may not resell them unless you register them under Section 5, which of course you don't want to do. Well, here's how you make things safe. On the security, you put with a legend. In other words, writing on the security, saying this is a restricted security. Go check with the company before you sell it, right? But then Rule 144 says, okay, in general, if I, the investor, I bought the securities from the issuer, if 1 year has passed and I'm selling to another private investor, then I'm okay under Rule 144. Oh, thank God, I don't need to register under Section 5. Right? That's kind of like slowly controlling how the stock spreads out. So just in general, if I buy from an issuer and I hold it for 1 year, I'm generally allowed to turn around and resell it to some other private investor. Okay, here's where Rule 506 breaks up into two parts. Right? There's B, which I think sucks, and there's C, which is awesome. All right. So recall that Rule 506, you can sell to an unlimited number of unaccredited investors. Sorry, accredited investors, my mistake. Under 506, you can sell to an unlimited number of accredited investors. Under Rule 506B, you can sell it to up to 35 unaccredited investors. Isn't that nice? 35 people with no money, you can sell to them. That's great. Okay, why in God's name would you sell to these unaccredited investors? They had no money. Okay, if they had money, they'd be accredited investors. Well, if you really, really, really want to do that, go ahead. I wouldn't. All right? Under both of them, like I said, you can sell to unlimited accredited investors. Now, here's where things get a little bit tricky. Rule 506 says no unaccredited investors. Forget it. You can't even sell to one. All right? So up to 35, none. And in both cases, unlimited accredited investors. Now, when someone under 506B tells me that they're accredited, well, yes, I make over $200,000 a year for the past 2 years, and I have every expectation it's going to happen next year. Can you believe them? The answer under 506B is, I don't care, okay? Because if they sign a document saying they've made over $200,000 for the past 2 years, and they have every expectation of getting it next year, or they have over $1 million of net assets, or they're a broker, or blah, 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 or I have reasonable knowledge and sophistication. I'm a sophisticated investor. If they sign a document saying that, they're doing what's called self-certifying that they're accredited. And unless you have a proactive reason to believe it's not true, you're like, thanks, cool, you're accredited. Yay. Yeah, it's cool. It's great, right? So if you do 506, even if, suppose you don't want to sell to unaccredited, because who would want to do that anyways, and you're selling to unlimited accredited, well, you need to get a piece of paper from them. It's called an investor questionnaire. They fill out the investor questionnaire. Yes, I'm buying with investment intent. Yes, I make this money. Yes, I'm this. I'm like, cool, great. Stamp, filed, received. And the SEC comes and goes, that person made $199,000 last year. They didn't make it $200,000. Bad. I can be like, I got my piece of paper. They signed it. Shut up. Okay? Because they self-certified that they're accredited.
It has to be a signed paper? Online form? Not applicable?
You can digitally sign it. The way it's done in real life is you give them an investor questionnaire, click, sign. Now, they can do that digitally, and I think that's actually more reliable. You just need to make sure you're in a state that recognizes digital signatures. I'm not sure, and because you're in Reg D land, I don't know if there's a SEC rule on whether it needs to be a physical. You don't actually have to get something signed, but you should get something signed. Okay, so you have a reasonable belief. Okay, the actual standard is, do you have a reasonable belief that this person's an accredited investor? Well, they told me they were. Really? Where did they tell you? Oh, it was over coffee. Prove it. Because they're saying they weren't. Oh, wait, I'm screwed. Okay? Do I have a piece of paper? They signed it. They dated it. Here, I got it. Do you have a reasonable belief? Yes. Well, they weren't. They lied on that. Yeah, but I had a reasonable belief. I mean, what do you want? Okay? So under 506B, reasonable belief is enough. Under 506C, remember, you can't do unaccredited. And they're trying to make really, really sure you don't have any poor, stupid people that you're selling to. You need to verify that they're unaccredited. Verify. In other words, you need to do your own little mini investigation that they're accredited. So it's not enough that they fill out that paper and sign it. You need to get proof, and I'll show you how to get that proof. Okay? You need to verify. They can't self-certify. They need to verify. So it's a higher standard, but there's a good payoff. Okay, under 506B, there's no general solicitation allowed. Remember, that would make it public, right? If I advertise to the world, it's a public offering. If I advertise to my good friends in this room, it's a private. So it makes sense that you're banning a general solicitation or advertising. Then you got the weirdest thing on the planet, which is under Rule 506C. You can have a general solicitation. You can advertise to everyone. What the hell? Reg D and 506 is based on 4A2. 4A2 says public offerings bad, private placements okay. But under this rule that's implemented under 4A2, you can do a public offering, you can do a public solicitation. You see the contradiction? What the hell? That means you can set up a website and advertise your token sale in the United States. What? That means you can send out group emails to everyone that you don't know. The poorest, stupidest person in Louisiana can get your email. This token's great. Why in God's name is that allowed? Okay? And here's my part. See the emotion in that italics? Wait, what? See, just imagine my voice the way I just spoke reading that. Okay, 4A2, on which Rule 506 is based, exempts non-public offerings, but under Rule 506C, you can engage in general public solicitation and can engage in general public advertising. Everyone together? POW.
Proof of work?
No, not proof of work. That'd be a lowercase o. Okay? But cute. All right? Whoa. Okay, so we'll get into this. Now, just to wrap up, under 506B, if you have any unaccredited investors, you need to provide them with information in writing. Just explain the security, explain the company. And if you provide to one unaccredited investor, you have to give that information to everyone. Okay. Now suppose under 506B you have no unaccrediteds. You just have accrediteds. You don't have to give them any information. You don't have to do an offering disclosure. You don't have to do a memorandum. You can just say, sign here. Here's the subscription agreement. Sign this. Here's your stock. Here's your tokens. Is that a good idea? We'll get to that. But if you have unaccrediteds, Any one of them, you have to give them certain information, which is defined by the SEC. If you have no unaccrediteds under 506B, you don't have to give them information. Now, in Rule 506C, it's kind of the mirror image of this. By definition, you don't have any unaccredited investors. So it's just clear. There's no mandatory information disclosure. You can just have them sign the agreement. Fine, there you go, issued. Again, maybe not a good idea, but you can. Okay. So the crux difference between these two is Rule 506C, only accredited investors. You have to verify that they're accredited. You don't necessarily have to provide them with information, but once you do those things, you can advertise to every frickin' human being in the United States, and that's okay. So if you're an ICO issuer, think what that does. At the very least, you're marketing. Suppose none of them buy it. Every single one of them, you just got to advertise your platform to. Wow. Unlimited people, unlimited money, advertise to everyone. This is awesome. Okay, now, how do you verify that they're accredited? What do you do? Well, they can't sign a paper. I don't know what to do. All right. You need the same investor questionnaire that you would always do. It's a good starting place. It's not sufficient, but you have them fill that out. And there's all these things you can do. You can review publicly available information. What really, really is strong is reviews of IRS documents showing income over the past 2 years. If they have tax returns from the past 2 years showing over $200,000 of income, then it's not your job to see if they committed fraud on the IRS. You can assume that those are valid. Okay, that's great. You can get written representations from them about their expectations for future income. Remember, it's $200,000 or $300,000 for 2 years back, and the belief they're going to have something similar in the future. They just can't say, well, I expect I'm going to earn more than $300,000. They can put in more information, like, I have these bonds, I have these stocks, I have this, here's how I expect it. Right? You can look at their brokerage, investment, or banking statements. If they have $10 million in the bank, you can be pretty sure that they have over $1 million in net assets, usually. Here's a good one. Representations from third parties, such as investors' accountant. If their accountant writes you a letter saying, this guy may look really stupid, but he has $1,001 of net assets signed here, then that's verified for your purposes. You're good. Here's a good one. There's use of certain third-party verification services. Okay, I think there's something called like accreditedinvestor.com. There's services that will go do the legwork of verifying someone's accredited investor status so that you don't have to do it. And as long as you make yourself reasonably comfortable that they're doing a good job, then you're okay. Right? You have to talk to them, you have to look at their procedures, you have to make sure they're doing their job, but then you can rely on them. And some of them are cheap. Okay, they'll check whether this is true for $10 per investor. Well, that's great. All right? So this is how you verify as opposed to self-certifying. You want the documents, and usually the lawyer's reviewing them and saying why. But I personally think this is going to be the future. Now, if the third-party thing, or if it's in the U.S., get a letter from the accountant. Really, get a letter from the accountant. I mean, it's like, send me a letter from your accountant. I mean, because accountants are fiduciaries, meaning that they're licensed professionals. Okay, if you are selling flowers in the U.S., you need a license, but there's not a special training. There's not held to public standard. Accountants, especially if you're certified, you're regulated. You're subject to discipline. You can assume that they're telling the truth legally, right? So I personally would forget the broker, unless it's a big company that I can rely on. Like some investment advisors I know are scummy jerks, but if the accountant is a scummy jerk, it's okay if they sign a letter. Don't work with scummy jerk. I'm kind of kidding. But get a letter from the accountant. Okay, the IRS documents are awesome. Okay, that's like gold. All right, and yeah, this is how you do it. Now, real life. Okay, I'm out there. I want to raise $1 million. Am I really going to go for this hassle for someone who's investing $1? No. Okay, they might as well be unaccredited investors, and I don't hang out with unaccredited investor types. You shouldn't either. Okay, so I only want money from people who have money, okay? Because who sues you? It's not the wealthy person. It's the idiot who had $10,000, gave you $9,000 because they want to retire on what you're going to do with that $9,000. All right? And they call you every day. What's happening with my token? What's going on? Forget it. Okay? I want wealthy people who don't want to waste time and aren't depending on me to could pay for their retirement. Okay, I don't want to commit fraud, but I don't want jerks. All right. So you focus on accredited investors. You set a minimum for them: $25,000, $50,000, $100,000. Okay, below which they're not allowed to invest. Okay, once someone's, I've worked on a deal recently where it's $250,000 minimum. Okay, if someone's paying you $250,000 minimum, I'll do this all day long. I think I can go to the effort of getting a letter from the accountant for $250,000. I don't know about you guys. It's okay. Or if I need to pay $15 to verify with some service that they're accredited, I think I'll do that, right? Because I want to keep my Reg D 506C exemption. Okay.
And the IRS documents, are they publicly available?
No. So you say, give them to me. And I would also get a letter from the accountant saying these are real. All right. Okay, so this kind of combined two things. Remember that it gets a little tricky. So okay, remember each one of these can be true. Any one of these can be true and someone's accredited. Okay, so the first thing is annual income of $200,000 or $300,000 with their spouse for the last 2 years. Here's the part: with expectation of earning the same or higher income next year or in the future. Well, it's reasonably objective whether or not they made $200,000 the last year. You can get their IRS report, the accountant can say so, all that other stuff. This thing about expectation of future earnings, that's subjective. It hasn't happened yet. You don't know. The accountant can't sign a piece of paper saying, I know for sure that so-and-so is going to earn more than $200,000 next year. Okay, because who knows? So that's a little bit more of a rational inquiry of, okay, you say you're going to earn $200,000 a year. You can't just say it, though. You need to tell me why. Okay. Now, you don't have to write a 12-page novel or essay. Right? The accountant can be like, he's got these bonds. They're producing this income. He's got this job. Last year he was paid this. The year before he was paid this. Even if it stays the same as last year, he'll make more than $200,000. Blah, 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 blah. It's not that hard. If someone's really a accredited investor and they're serious, shouldn't be an issue. Right? These two just kind of really go together. You need the last 2 year proven, and you need a rational basis for believing that's going to happen in the future. Okay, now, remember that, let me go back here. Remember that one of the factors that the court looked at for whether or not something is private and not public is the extent to which documentation was provided to the investor. And hold on here. Okay, this one. The issuer provides either an offering memorandum or there's sufficient public information about the issuer. Okay, provides an offering memorandum. In other words, do they provide adequate disclosure? And then under 506C, if you have an unaccredited investor, you have to give them the document because they're too stupid to understand words that are spoken. They need some document that they can give to their investment advisor and go, is this a good investment? All right? And the idea is if you have and once you do it for one unaccredited, you need to do it for everyone. 506C, it's not technically required to provide anything in writing. What should you do in real life? All right, in real life, consider every single thing you say that's true is something that the person can't sue you for. Okay, so it's not that you have bad information. Okay, it's that you didn't disclose it. Okay, if someone was convicted not of a bad actor type thing, but of robbing a bank 5 years ago, right? I want to know whether or not someone who's running my company robbed a bank 5 years ago, right? If I leave it out of a document, that's probably a material omission, omission of material fact, which could be fraud. If I put it in the document, even if someone doesn't read the document, but you give it to them and they can evaluate it before, actually you make them sign something saying that they read it, but you encourage them to read it, you disclose all the facts. They can't go, and then the stock goes down because it becomes publicly known that this guy committed a bank robbery 5 years ago. The person who bought your stock in the first place, who knew about that, can't complain because they knew about it. Right? You can only complain about things that you're lied to or that you don't know. Right? If people can't say that you lied to them or you didn't tell them something, they can't sue you for securities fraud. So, technically under 506C, there's no requirement to provide them with documentation. You can just have them sign an agreement. Is that smart? I say no. I at the very least want to give them a term sheet, which is a sort of summary of what I'm selling. What I would really want to do is, if I'm providing more than a couple $1 million of securities, do a full private placement memorandum. Okay? When you do a public offering, you have a registration statement and prospectus. When you're doing a private sale, the typical term is a private placement memorandum, or PPM. You hear that all the time, right? And so your PPM talks about, it's like a miniature prospectus without being quite as formal. This is the company. These are what we're selling in terms of security. Here's the management. Here's our discussion. Here's our financials. They've been audited. Here's our projections. Here's our technology. Here's our competitive environment. It's all the stuff you'd normally put in a prospectus. And every single thing you say in there that you reveal, and everything you don't hide, and everything that's true, is something you're taking away from the person to sue you. Now, if you look at these documents, there's a really important section called risk factors. All right? Risk factors lists all the things that can go wrong. Martians may come down and eat us all alive. The internet may fail. Bitcoin may get hacked. Okay? The more you list things without going too crazy with it, every single one of those that you list, if that thing actually happens and the investment goes down in value, the buyer, so long as they have that risk factor disclosed, can't successfully sue you for it. Right? So a big important part of your disclosure documents, even if you do a short one, even if you do a term sheet, right, is you list out the risk factors. You can technically not say anything positive about your company. If you just say the bad stuff and someone signs off that they received it, technically you're fine. Because if you left out the good stuff, that's only going to make the stock go up. They're not going to sue you for information that's positive that you left out. They're going to sue you for information that's negative that you lied about or that you omitted. Right? So just in terms of practical reality, when you're selling your tokens or your stock or whatever, include your risk factors at the very least. So just kind of wrap this one up. Okay, it's true that there's not mandatory disclosure under 506C, but disclosure is good. You should create a proper offering memorandum, PPM, or term sheet. Okay, and just like a morality checker. You're taking people's money. Okay, it's important. They deserve to know what they're investing in. Give them full disclosure. Okay. Also, a well-drafted offering document is good marketing. Wow, I really want to invest in this. This is a good explanation of what I'm doing. If your marketing document, if your PPM or prospectus when the person's done reading it, if they don't want to invest, you need to think about either A, how you're writing it, or B, whether you should be in business at all. You want to say the complete truth and without lying, without leaving people out, and people should be excited about investing in your business. If you have trouble drafting your document so that this is the effect, you need to think about what you're doing, because that means there's a flaw in your business model. Okay, like I said, the more you can accurately disclose, the less you can be sued for. And again, punchlines. Use Reg D, Rule 506C, to conduct a private placement to raise unlimited capital from unlimited investors. Verify that they're accredited. Don't take their word for it. In other words, they can't self-certify. Don't mess around with grandma and other unaccredited investors. Steer clear of bad actors. And don't make any misrepresentations of material facts or omit those out when selling securities. And you guys have been troopers. You are strong people. I like this. And we're done for today. Come, my friend. If you don't clap, I'll be sad. We're done with the presentation. Questions?